May I have your lordship's kind leave to file this memorandum of appeal, my lord, without certified copy? Order was passed on October 24th. Order was made available on server yesterday. And to move this application, my lord, any day this week, my lord, there is urgency. My lord, I can explain your lordship.
Give 48 hours notice and give
Yes,
the
I
date.
40. I can serve, my lord. Dr. Shutanu Patri is appearing on.
No, that way we cannot give it.
My lord, on Friday, my
Granting
lord.
you leave,
My lord,
file it with the returnable date with 48 hours notice.
my lord, the difficulty is, my lord, I tell your lordship.
48 hours comes
No,
within this week.
now this system, my lord, if I file today, 48 hours comes to Friday, but the department will not accept. They will say it will take time for scanning and everything. You have to give date on at least on Monday. This is the procedure they are following.
Give it on Monday. Leave granted. Yes.
Lordship, may I be permitted to have your lordship kind permission to take a leave to file an application for addition of party, your lordship? It is a matter relating to take 2022 wrong assessment of.
Why you are mentioning today? Today is not the mentioning date.
Yes, your lordship. The difficulty is, your lordship, on 31st. I mean, that is on Thursday. Your lordship has fixed for final order.
Which
And
one? Which one?
The
Which
take 2022 wrong assessment of answer key. Yesterday, your lordship has passed.
state?
Lordship.
Which matter you are saying?
2022 wrong assessment of answer key. Wrong question matter. An appeal was filed, and yesterday your lordships were pleased to pass an order to fix the matter on.
Yes. What is your that has been
final
on
order, your lordship.
fourth. We have fixed it on 4th.
No, 31st of October, your lordship.
Oh, yeah.
That is on Thursday, your.
So they will file a report and we will discuss.
Yes, the lordship, the petitioners are the aggrieved and similar circumstance petitioner. So I am praying for your lordship to leave the.
Why didn't you come earlier?
Lordship, at least when the appeal came, that was the last day of court before the puja vacation, your lordship. And yesterday, that is on Monday, the petitioner who will affirm could not appear, your lordship. That is why I am mentioning today. If your lordship can kindly give me the leave to file, I will leave and tag the matter in 31st, your lordship.
Number one, Malat. Malat, I am praying only 1 day accommodation. Malat, I am not ready with the brief today, Malat. Only 1 day. Malat, tomorrow I shall do it, Malat.
Malat, there is a Malat, section 5 application with a delay. Malat,
delay is of how many days?
Malat, total delay 74 days after statutory period. There would be Malat
44 days.
44 days. Delay may be condoned.
Now, what is your, where is the order? You are the writ petitioner.
My lord.
Higher pay scale.
Higher pay scale.
Writ petition was on affidavits.
No, my lord.
Omlan, which is
by the special bench judgment Utpal Kanti Kaur. That is my.
then he is entitled.
No, my lord.
No. Why?
Because, my lord, their But there was a mistake on the part of the School Service Commission. She got appointment as past graduate teacher, but in her qualification, it has been endorsed that MA. Though, my lord, the sanctioned post was past graduate in history.
Which subject?
History. She having, my lord, MA degree, but the post was,
She appeared in graduate post.
yes,
Very good. Now was given the graduate skill.
yes,
Now he made an application that give me postgraduate skill.
yes,
Rejected by DI.
yes.
Where is the DI order?
DI order, my lord, page 74. And I think, my lord, my brother, Mr. Badi, is not ready, my lord,
Agree?
not ready with the, my lord, merits of the case, my lord. So, my lord, kindly take
We are
an
also not ready with the merits.
Yes.
We are going through it. We are also not
only,
ready.
my lord, I have to, my lord, demonstrate the, my lord, special page judgment, which part I do not have, my lord, today.
পেলে নাকি? হ্যাঁ? Section 5 টা allow করে দাও। 10th.
10th.
We are allowing the section 5.
Grateful, my lord.
Appeal has been filed.
My lord, I am appearing for the board, my lord.
Lord, petitioner appellant, Lord, I am bringing 2 days time because Lord, I could not annex some documents where relevant. I have to supply the done at this time.
2 weeks. 2 weeks do the needful in the meantime.
My lord,
Lord, in the meantime, section 5 may be. There is an application for section 5.
Then place it why you are seeking adjournment.
So there is delay of 356 days. 356. I am explaining.
You want to use an opposition?
I am explaining.
No. Who is the state?
my lord,
Lord,
that I don't.
What happened, Lord? I have started a copy, Lord, indicating the matter will be taken up on Friday. On that, Lord,
You have given notice or for?
on Lord Friday. Matter will
Lord,
be
matter-
taken up on Friday.
Matter is to be taken up on,
On
supposed
Friday.
to appear on this Friday.
This Friday.
Notice.
Notice
As per
I have
notice.
Done. Friday the
Yes.
yes.
Agreed. Order.
Yes.
Order হবে। Order হয়েছে তো দাদা?
No. Friday it will appear.
Yes, Friday.
Small order may be passed.
What order will be passed? This was. Come back on that date.
Right.
Yes. Yes.
No, no, order. My lord, I am appealing for the university, my lord, that your status matter, my lord. Is there, my lord.
My lord, this matter, may I tell before your lordship, my lord. My lord was kind enough to hear this matter before vacation. Now, my lord, there is an order of the coordinate bench. There is already an order of the coordinate bench, the division bench. That, my lord, whereby, my lord, that the directing the finance secretary to call for records from the Kalyani University with regard to the status of those, my lord, the casual or, my lord, the employees, and, my lord, to revise the remuneration in terms of the memorandum. That was, my lord, issued time to time after 2011 till 2019. Now, my lord, that order is dated 30th of June 2025. Now, my lord, the paragraph number 5 is the, my lord, the order passed in the during pendency of the appeal. Now, my lord, the appeal was preferred by the writ petitioners because 7 except that it has been recorded that memo of 2019 has been followed. It has been recorded in the order of the learned single judge, whereupon the appeal has been preferred that 2019 memo with regard to the, my lord, the remuneration of the casual employees by the of the university has been followed or implemented by the university, and no further order can be passed in the single bench judgment. Now, before the division bench, when the matter was taken up, because they are deprived, because they, my lord, prayed for regularization. Now, my lord, in the appeal court, my lord, an order was passed as an interim order directing the, my lord, the finance secretary that after taking the consideration of the inter records from the Kalyani University, then you have to take a decision. Now, my lord, there are several, my lord, the GO, my lord, knows time to time issued. From 2011 it started, 2019 the last, and then 2013 one amendment. Now 2019 it appears from the single bench order already complied with. Now, my lord,
We did
now, my
not
lord,
call
me,
for-
me I tell. Now, may I tell, my lord. Now, today, may I tell. Now, my lord, university, on the basis of our requisition, they have already submitted some papers or documents with regard to their status. That how many years they are rendering their services, what is their present remuneration they are now, my lord, taking or withdrawing, and other. But with regard to consideration of those memo from 2011 to 2019, certain other, my lord, the information are still, my lord, we wanted from the university. We have also informed the university. Because of this long vacation, my lord, either they have not able to supply or provide us, or we are not
What,
getting.
Mr. Sen?
Madam, may I tell, madam, 10 days time be given so that I can file the affidavit or report in the form of affidavit as directed by this court. After considering this, my lord, the rest of the papers or documents which we, my
No,
lord, fought for.
when Mr. Bhattacharya pointed out the direction was upon the
Direction was
Secretary.
upon the finance secretary. The
Principal
finance,
secretary,
because the
yes.
finance secretary was
Okay.
not a party originally.
Maybe, but
Yes.
the report has been filed by the additional chief
That
secretary.
is the earlier.
No, no, your junior filed a report.
Additional chief secretary.
Additional,
Principal
my
secretary.
principal secretary is also additional
Additional
chief secretary.
Same person.
Same person.
I see.
Additional
Same
chief
person.
secretary.
I am told, I am not
Additional
aware.
chief secretary হয় যে প্রিন্সিপাল সেক্রেটারি হয় যাদের সেক্রেটারিতে সুপারঅ্যানুয়েশন হয় স্যার চিফ সেক্রেটারি হয় না অ্যাডিশনাল
But my lord, may I tell you, that report already filed on the day when that matter was taken up and personal.
No, but perhaps, my lord, my lord, but
Subsequent report to file হয়নি।
my lord,
The
তো file হয়নি এখনো। No, another report,
আমরা
আমি
কোনো
তোমায়
order pass
বলছি শোনো।
করেছিলাম?
Another report which was directed to
my lord, after this order that your lordship is looking at of 30th June 2025,
Yes.
when, my lord, in view of the problem created, my lord, the principal secretary and the registrar were both directed to be personally present before this honorable court. My lord, in their presence, an order was made by the coordinate bench directing, my lord, what my learned friend invited your lordship's kind attention to, paragraph 5 of the order. Now, thereafter, we were, on 24th September 2025, a gentleman by the name of Prabhat Kumar Mishro, in his capacity as the Additional Chief Secretary, Finance Department, sought to file an affidavit before my lords. When the matter, was returned to your lordship, upon change of determination. My lords were not kind enough to accept the report in the form of an affidavit and were pleased to return the report
Yes.
to my learned
That is with
friends.
yes.
রিপোর্টটা কেননা
And
may I tell, Malad, it was
What is the date of affirmation of that?
Malad, this
24th September 20, he has in fact served a copy
24th
on me.
September 2025 report copy already it was served upon my learned friend.
এটা আগের রিপোর্টটা আর্লিয়ার রিপোর্ট আর্লিয়ার
যেটা অর্ডার যেটা ফাইলে আছে রেকর্ডে আছে ওটা আর্লিয়ার রিপোর্ট সেটাই আমি
Recording নেই, sir.
ওরে বাবা ওটা আর্লিয়ার রিপোর্ট একটা ফাইল হয়েছিল যখন তোমার ওই
In 10 days, we will
My-
hear it on that.
my-
Give a copy to Mr. Bhattacharya when it is
not this but the fresh
one,
fresh
so
report.
that we can hear it.
My
You are wanting 10 days, we are giving you some more time so that you can give a copy to Mr.
oh yes
Bhattacharya, right?
my
In terms of the order,
One day. 17th,
একদিন ওর বাড়িতে খালি
the 30th June is the order, kindly recall.
One day, my lord.
What one day?
Instead of 20th, kindly fix it on 21st or any other day.
Why you are not coming on 20th?
19th and 20th, my lord, I have some personal difficulty, my lord.
প্রত্যেক ম্যাটারে তোমার
And 17th is a Monday if it comments to your lordship.
24th রেখে দাও।
Grateful.
24th করে দাও।
A grateful man.
Item number 4. Item number 4, I am for the appellant, lordship. I may be allowed to submit virtually, lordship. Item number 4, I am for the appellant.
Who is your other side?
Lordship, the service has not yet been effected, lordship.
Lordship, I'm appearing,
State
but I'm
respondent.
appearing without service. I have not been served with anything. I'm appearing for only 3 respondents, but I have not been served with anything. I have watched the list and appeared.
Alright, we'll take it up on 10th November. You complete service.
Lordship.
10th November.
Grateful, Lordship. Deep love.
Item number 5, my lord, I am for the appellant. My lord, it was due to appear, my lord, tomorrow. But my lord, your lordship, the similar, my lord, the appeal, my lord, our appeal, your lordship fixed it on, my lord, 6th November. So if your lordship, my lord, tag with the, my lord, served, my lord, my learned friend is appearing.
6th November করে দাও।
Grateful, man.
Grateful, lordship.
Grateful.
Yes.
পরেরটা তো ওদিকে। পরেরটা মানে
Item number 6, my lord, I am for the appellant. Actually, I am praying. My lord, I am praying for the 1 week adjournment, my lord.
Sir, why do you bring the matter in the list? We don't force you that you do it on that day.
Sir.
Does it seem good? Since the morning, matters are adjourned.
So in this matter,
Since we do not have the tendency to dismiss for default, if you do like that, court gets irritated. If you are not prepared well, we are not saying that you have to be prepared on that.
now in the,
When the matter appears, sir, make an endeavor that when the court has fixed, let us go.
Well, since 2009, my lord, I am suffering, my lord. I have get the order. And my lord,
lord-
we have preferred an appeal. In fact, we have filed a contempt application.
Item number 6. Yes, what is your problem?
my lord, in a common judgment, there is 2 appeal was filed. One appeal is listed here, and other appeal is not yet listed, and in the list, and it will be heard in analogously.
2 appeals. My lord, we did not, my lord,
In
prefer
this
an
common judgment, it is appeal is filed for the common judgment.
Filed 2 appeals.
Yes, my lord.
This Kanailal Bodua filed 2 appeals.
Yes, my lord. Now, Kanailal, my lord, it is separate appeal, which it will be heard in the analogously because
Told you that analogous hearing direction was there. It is arising out of the same judgment.
yes, my lord, common judgment.
2 writ petition, my lord, it has been disposed
2
of.
appeal, you are appearing for the writ
Yes.
petitioner in 6.
Writ petitioner, my lord, the respondent writ petitioner. Yes,
So when the writ petition was heard,
my lord.
writ petition was by multiple petitioners.
No, one, my lord, the appellant, one by, my lord, my client. Both the writ petition was heard together,
Oh, one by the him
Appellant.
and the other by you.
my lord.
So he has preferred, your court has held in your favor.
Yes, my lord.
So he has come up in appeal.
Yes, he has
Then
come.
which is the other appeal you are speaking of?
My lord, it's the other appeal, MAT number 1459 of 2005-25. It's filed.
That your friend is appearing?
Yes.
Yes, my lord.
Eh?
Yes.
1459. Yes.
If this
No, 1459 is appearing, my lord.
1459.
1458 is appearing.
Yes.
1459
9 was yet to be, it was filed, it was not yet listed.
No, only one appeal has been served, 1459, and that is appearing in the list.
It is not appearing in the list.
It is
The
1458
matter
is
listed
appearing.
is 1458,
8 is appearing, yes, my lord.
and you have not served that.
1458 has not been served.
Yes, my lord. It
Oh,
has.
served it.
Yes, no, 1459 is not yet served, my lord.
At 9 he has got, 8 he is saying. The matter
not
which
yet
is
been served.
appearing is 1458.
Have you
I
served
do not know who is
1458?
preferring another appeal.
My lord, kindly 1 week adjournment, I will be checked.
8. The 8 is the
Explaining করতে পারছে না, দুটো appeal জানা নাই। আচ্ছা, the other appeal which you are saying, that has also been filed by Kanai Lal.
Yes, my lord.
এগুলো
Kanai-
বাড়িতে দেখতে হয়, এগুলো বাড়িতে বসে চেম্বারে চেক আপ করতে হয়।
কানাইলাল দুটো অ্যাপিল কি করে ফাইল করলো?
না, কানাইলাল নেই, আপনাকে বলছি এটা একটু দেখে।
How the my lord Kanailal has filed 2 separate appeal? I do not know.
We are now presently Kanai Lal. We don't know what has happened.
ও তো বলছে দুটো করেছে।
Give the number of the other appeal and the name to our court officer.
Yes, my lord.
Write it down. Write it down.
এই তুমি
One-
Take a slip. Write it down.
আচ্ছা,
The number.
এটাও কানাইলাল বাউরি, এটাও কানাইলাল বাউরি।
চুপ করো।
Have the copy.
yes, my lord.
Have the copy of the appeal.
Yes.
Next Thursday করে দাও। Thursday week
Yes.
করে দাও।
Next host.
Yes.
Great.
না, next Thursday তো ওর ছুটি নাকি? না, না। আচ্ছা, Thursday. Next Thursday.
Thursday. Yes, my lord.
Thursday week, 6th November.
Yes.
Direction to serve the other appeal.
Yes, my lord. Yes, yes, my lord. I'll solve.
6 আমাদের অন্য কোনো মামলা আছে?
Any difficulty by any of you, tell us. We will fix that date. Again, don't take adjournment. হ্যাঁ কি অর্ডার পাস করবো তো অ্যাপিলটা ফাইল করে তো ওইটা তো জাস্ট ইয়েতে করা ইয়েস নেক্সট সেভেন হু ইজ ইন সেভেন ডিসমিস তো করতে পারবে না সাহেবরা তোমার তো রেজলিউশন নিয়ে রয়েছে নট টুডে নট টুডে করে রাখো
I'm for secondary board, your lordship.
Well, Advocate Bhubruvan Bera is appearing in this matter, but right now he is in Bangalore for his mother's treatment. Yesterday, I'm also
when did we keep that matter of yours
yesterday,
Huh?
11th November.
এটাও 11th November 11th November
11th November. Order হচ্ছে না। I don't have a time.
Third November, Your Lordship. The listing date was given as 3rd November. However, suddenly it has appeared today's list.
why madam 3rd November this
At the time of filing, it was listed on 3rd November, Your Lordship.
it will be on 4th November
4th November. Okay, Your Lordship.
you're for the appellant
Yes, Your Lordship. Petition appellant.
so tell us when do you want it have you completed service
No, Your Lordship. It's not yet completed.
24th September you filed it you have not completed as yet tell us what is the matter then
Lordship, I am not briefed in this matter, Your Lordship.
you are not briefed you are not the advocate on record
No, Lordship. Mr. Shutyaranjan Kundu is the advocate on record.
he instructed you over phone oh then when can you complete service tell us madam
Lordship, service has been done, but it has not yet, like, it's not yet reached. It has been sent, but it's not yet been received.
কোনদিন কম আছে অম্লান সেদিনকে কি অম্লান আসছে না পুরো Same advocate.
Yes, my lord.
You are there, Mr. Chakut.
For the state in item number 11.
What is the matter about?
My lord.
Matter about?
Mathematics, it's
Challenging the notification of second SLST.
Second,
SLST, the new SLST 2025, the notification issued by School Service Commission.
huh?
So there are several challenges of different aspects. So this is challenging that notification.
Then what did the single judge say?
Single judge, your lordship.
We are the division. Single judge must have said something. Oh, you have not read the order.
Actually, my lord, the answering respondent is School Service Commission.
So you will not read.
no,
This is
my lord, the single judge has relied upon my lord two judgments, one of the Supreme Court and of the state of West Bengal, my lord. Another one.
those
Those
judgments.
two judgments,
And on basis of that,
and the writ, and relying on those two judgments, my lord, the writ petition was dismissed, stating that, my lord, this will
No, what was his grievance in the writ petition?
the grievance of the writ petitioner was that he should be allowed to participate.
no, participate in the upper primary.
Upper primary.
Now here, my lord, the participation is not in the upper primary. It is in the 9, 10 and 11, 12. And the upper.
Item number 11. Yes, when did we keep your matter?
11 November, my lord. Finally.
Come on, 11 November.
Not.
Please bring the copy of the judgment
Yes.
which the single judge has proceeded. Now the advertisement was of the year 2025.
25 for class 9, 10 and 11, 12.
Now interview has been done.
No, my lord. Now the
Examination is going on.
examination is going.
There is a written test, na? That is over.
No, my lord, that is not yet over. It is going on.
So
He is not asking for employment participation in 9, 10, 11, 12. He is asking for participation in upper primary. That upper primary panel expired in 2019. And
then why he is challenging this?
because your lordship, your lordship, in another matter, the state has decided to create some supernumerary post for upper primary. That was also under challenge, and there is a
we have state.
Yes, state. So, my lord, he's as per my understanding, because there is a supernumerary post, so he wants to participate in that.
All right, come back. Yes, next. Why there is no lawyers have not come. এটা তো কেউ আছে না কালকে সবার
Here. 13. 13, my lord, I am for the appellants.
Who is opposing you, Mr.?
West Bengal Board of Primary Education.
Led by Mr. Sandal.
This is my affidavit of
State.
Out of time.
Yes, my lord, out of time. Delay of 67 days, my lord. My lord, in the writ petition, my lord, affidavit was called for. My lord, I am contradicting the statement submitted by the submission made by the West Bengal Board of Primary Education, based on which the affidavit was called for. My lord, we have waited for the affidavit, but the subsequent action by the West Bengal Board of Primary Education prompted us to file this appeal, my lord.
Prompted you to file
this instant appeal. May I place the facts, my lord?
issue before your lordships are whether in a public employment merit should be the only consideration instead of whims of the recruiting authority, my lord. My lord, this recruitment notification is of 2022, precisely 29 September 2022.
You are challenging the order of 17th June.
Yes, your lords.
Yeah, give us 2 minutes time. Now, then why you have come up against the order?
Your lordship, my lords, kindly consider the previous order dated 6th of May 2025.
Where is it?
My lord, I have annexed.
Annexed to the stay application?
Annexed with the memo also, my lord.
Previous order?
Previous orders. 6th of May 2025. And in the stay application also, my lord, page 254.
So you have completed the DLED course prior to 2020.
My lords.
So in the recruitment process which commenced by the advertisement of 29 September 2022, in that the DLET, the persons who completed DLET in 2020 and 2022 session were allowed to participate.
Initially, they were allowed, but subsequently, by the order of the Honorable Division Bench, they were excluded.
Then Supreme Court said that you cannot exclude.
Yes.
Now, you are persons who are completed prior to
2020.
You were allowed to participate.
Yes. Now, I am saying that there are remaining vacancies of 2,533, according to the submission by the board. I am saying
1,533. Very good. Vacancies.
My submission is that these vacancies should be filled up in accordance with merit by and between us and the 2020 and 2022 DLED candidates.
Now, any post has been filled up?
No, not yet. But they have taken steps.
None has been appointed as yet.
But they have taken steps. They have filed application before the Supreme Court and obtained an order to fill up those vacancies by 2020 and 2022 DLED candidates within 6 weeks.
Then why didn't you add yourself in that
My
Supreme
lord, we
Court?
didn't have the scope. We didn't know that. My lord, they filed an application, and the candidates who are the beneficiaries of the order of 2020 and 2022, they have preferred the contempt application. That was heard in a single day, and a consent order was obtained, my lord. Since the state is also agreeable, my lord, we didn't get any chance. May I place the facts, my lord? Everything will be clear, my lord. They are shielding the Supreme Court order, stating that these vacancies should be filled up only by 2020 and 2022 DLED candidates. Supreme Court has never said that. That is our grievance, my lord.
So for that reason, the court has called for affidavits.
My lord, court has called for affidavit based on submission made by Mr. Sannal, stating that Supreme Court said that they should be appointed. Supreme Court has not said that only they should get appointment.
So they have not filed that.
No, not yet. But they are taking steps to fill up the vacancies, my lord. Since 6 weeks has already been elapsed.
My lord, we will file affidavit, my lord. If your lordship take, my lord,
File affidavit.
no. We will file affidavit, my lord.
So by that time, the vacancies will be filled.
Yes, my lord.
How my learned
should be demand.
My lord, how my learned friend, my lord, apprehend that their merit, my lord, the candidate will be appointed less meritorious than the candidate of the, my lord, present petitioner. How my learned friend is apprehending? My lord, I could have understood, my lord, one is, my lord, non-absorbed. My lord, my lord, I just narrate your lordship the facts. My lord, there were 11,000 on odd vacancy, 2022 recruitment process. My lord, 9,000 and odd were
appointment to the poster.
Primary teacher.
Assistant primary
teacher. 2022 recruitment process. My lord, 9,000 and odd were appointed. My lord, pursuant to the order of the Supreme Court. My lord, in 9,000 and odd, my lord, they were considered, they didn't come within the zone of consideration. That is why they were not given appointment. My lord, thereafter, my lord, pursuant to the order, my lord, series of, my lord, litigation, my lord, before the Supreme Court, my lord, Supreme Court, my lord, the one of the litigation, my lord, 2022, my lord, batch, those who, my lord, completed, my lord, DLED course, my lord, that batch, my lord, got the order, and my lord, ultimately, my lord, board proceed with this matter.
Only restricting it to 2022.
My lord, we cannot give any appointment. The board cannot give anyone appointment, those whose score is less than the candidate already given appointment. Mala, it is not that. Ultimately, Mala, panel is one, your lordship. Mala, 2022 recruitment process. But if my learned friend Mala can show before your lordship, one has been appointed less than the number of the petitioner, then Malad, his case, Malad,
Were they in the panel? They were not.
No, not at all panel, but they were participant.
They participated.
Participated.
So your contention is they did not fulfill the merit criteria.
Merit criteria. Now they are saying
they were not empaneled also.
No, not empaneled also.
Because they did not
come within the Malad, the zone of consideration. That is why they didn't empanel. Malad now 2,500 and odd Malad the remaining vacancy. Malad pursuant to the order of right now, Malad, I'm not armed with the order of the Supreme Court, but I know by the order, my last Malad order, the Supreme Court permitted Malad or Malad directed us to give appointment of the candidate already got order from the Supreme Court in batch of 2022 selection the DLED courts.
No, is it your stand that none of the persons who completed that course prior to 2020 did not come within the zone of?
No, not at all, not at all. Malad, they were considered. It is not that since their qualification prior to 2020, this is not the case. They were considered. They didn't come within the zone of consideration. Malad, because of the Malad long vacation, Malad, I do not know the Malad exact Malad the position Malad of the recruitment. If your lordship take it up tomorrow or day after tomorrow, I can Malad ascertain the present position and Malad the status of the.
Mr. Biswas, please explain to us.
Malad.
Panel which was prepared was considering all candidates.
All candidates, except 2022 recruitment process. Sorry, Malad, 2022 batch of DLED, diploma in elementary, those who completed diploma in 2022 batch.
They were also considered.
They were not initially considered because
but ultimately they have been considered.
Ultimately now they are considering. because of the order of the Supreme Court.
Prior to 2020, the zone of consideration. No. The appellants were already in the zone of consideration and had been considered. Because 2022, that session
Not
was
zone of consideration, as a participated, they were considered. Their candidature were considered in the recruitment process.
this 2022 was a subsequent thing because they were not considered.
They were not considered.
So by the
So
order,
Supreme Court said remaining vacancy, you considered them. But we cannot.
no,
Malat-
just a minute.
Yeah,
Supreme
yes.
Court said these persons who had not been considered 2022, you consider them now for the remaining vacancies. But does it mean that they are to be reconsidered again? These persons.
Malat, I tell your lordship,
they have already
Malat, subject to correction, Malat, I tell your lordship, I got your lordship. Malat, one cannot be appointed. Suppose Malat 2022 recruit Malat batches where now they are going to be appointed. Cannot be any person cannot be appointed less than the marks of the petitioners. Cannot be. Malat, then automatically Malat their chance will come and Malat we have to give appointment.
So
May I Malat, am I clear to your lordship?
You've understood. So you're saying this is a preemptive appeal.
Absolutely. Malat, the appeal is itself not matured yet. Because your lordship, this is Malat, how the mandamus appeal can be Malat against the Malat this order Malat order of June, your lordship.
May I get 5 minutes of your lordship?
What 2020 to 2022 DLED candidates were not being allowed to participate
Yes.
in the recruitment process initiated by the memo of 29 September 2022.
Exactly.
Initially, they were participated.
Let me understand. That dispute ultimately went up to the Supreme
Court.
Supreme Court said
Ultimately,
that
142
considered
Supreme
them.
Court, yes.
Now, before the Supreme Court direction was passed, the selection process continued. Panel was prepared.
Panel was prepared even pursuant to the order of the Supreme Court. Panel prepared and 9,000 were given appointment, excluding 2022 recruitment process initially. Thereafter, at the time of final judgment, 2022 Supreme Court said 2022 you have to give up.
So in that 9,530,
They were considered. They were considered.
So they were unsuccessful.
They were unsuccessful. Malat, give me 1 minute, Malat, more, your lordship.
How the writ petition was entertained.
Malat, writ petition, Malat, their apprehension, Malat, that we cannot be considered, Malat, their apprehension.
They may be excluded.
They may be, Malat, their contention.
Not excluded. They have already been considered.
They are already been considered.
And they did not come
Within the zone of consideration. Suppose your lordship today, Malat, when we are giving Malat appointment of 2022 batch, suppose the petitioner got in the selection process, suppose petitioner got Malat 10. Suppose Malat, I cannot appoint any person.
Below 10.
Below 10.
Cannot.
So put that line in your
Yes.
evidence.
I will, my lord.
That is the stand of them, my lord. We have no grievance.
I will, my lord.
Because that is the exact grievance of us. We are apprehending the application.
We will record that he will be submitting upon instruction that pursuant to the Supreme Court order, the appointments which are being made, in which you are saying that you should also be considered. He will make a statement that no one will be appointed who secured
Less marks than me.
than this.
Absolutely.
My lordship, your lordship keep it, my lord, next week. My lord, your lordship keep it to the next week. If required, my lord, I will come with the written instruction. I'll so that.
But Mr. Vishwas, why haven't you filed the affidavit before the learned single?
My lord, I tell your lordship, my lord, frankly, my lord, I tell your lordship, my lord, every day, my lord, the alternative day, my lord, the application is being moved before the Supreme Court. Every day, my lord, order is, my lord, coming from the Supreme Court. My lord, we are really, my lord, because of the, my lord, because of the fault, my lord, any of the, my lord, this, my lord, has happened. Because initially we permitted 2020 candidate to, my lord, participate in the selection process. Thereafter, interference of the court.
My lord.
What is it?
There are some confusions, my lord. My lord, kindly allow me 5
No,
minutes. My lord, with
just
list of dates, my lord, may I submit?
List of dates.
My lord, with the dates, my lord, may I place the facts, my lord?
Why should we go into that? The problem will be solved.
If this
You are
solved, my lord,
saying-
then I'll.
You are saying that the problem will be solved if this statement goes in the records.
Yes, absolutely.
Your lordship,
If they say that no less meritorious candidate will be allowed to appoint, then our problem will be solved. Like, that is exactly our grievance, my lord. The appointment should be made in accordance with merit, descending order of merit.
Prior to the appointment, why are you assuming that there will be an appointment of persons less meritorious than?
Page 261, my lord, what they have stated before the Supreme Court, kindly see, I have annexed their application. They are concerned only about the 2020 and 2022 candidates. Whereas, my lord, Honorable Chief Justice of India,
absolutely, my lord, because
to
of the
consider
Supreme Court's
another
order.
set of candidates. They have not stated anything about these candidates also. The NIS candidates. The NIS candidates, my lord, who has been excluded from this recruitment process.
My lord, now
even
my
they,
lord, friend is jump, my lord.
because they have stated in their miscellaneous application filed before the Supreme Court that they will consider only 2020 and 2022 DLED candidates. How they can, when this order is existing, when our order is existing?
So that is he saying that your case has also been considered.
My lord, I am saying that in the remaining vacancies, Supreme Court has never.
In the remaining vacancies, we are not concerned. We are saying that whether you have been discriminated or not.
Yes, if they consider
you are
the
already in the panel. If you are already in the
no, I was not in the panel. My lord, may I just, if your lordship kindly allow me 5 minutes, my lord, I shall place them. My lord, kindly see the date of notification. My lord, your lordship need not have to open the brief. My lord, may I place the facts? My lord, on 29th of September 2022, candidates of 2020-2022 DLED batch preferred a writ petition before this Honorable High Court that was heard on the 29th September 2022. Their grievance was that our court should have been concluded within 30th June 2022. Due to latches of board, West Bengal Board of Primary Education, we could not complete our course within stipulated time, that is 30th June 2022. So they apprehended that if any recruitment notification comes, they will be excluded since their training qualification is incomplete.
Very good.
Before the single bench, board said that we will consider their candidature. So a consent order was passed by the single bench stating that 2020-2022 DLED candidates should be considered in the recruitment.
Who obtains the
yes.
qualification.
Now recruitment process goes on. In the same days, they come with the recruitment notification. The vacancies disclosed therein is 11,765. We have participated in against those vacancies, 11,765. My lord, during the process of interview, we have been interviewed. During the process of interview, my lord, order of single bench allowing 2020-2022 DLED candidates.
No, you were considered.
Yes.
Now you came within the panel.
My lord, that is my case, my lord. My lord, our interview was over. But by that time, my lord, 3 appeals have been preferred before this honorable division bench, challenging the order of single bench, allowing 2020-2022 DLED candidates.
That order was passed after that consent order you are saying?
Yes, the consent order was challenged before the division bench by some other candidates, my lord, who are TET qualified, who said that since their degree is incomplete, they should not be allowed to participate. So by order dated 11th April 2023, this honorable division bench.
TET qualified, that is the DLED. That is the teacher eligibility test is something else.
Yes, teacher eligibility test is the eligibility, but to participate in the recruitment process, one has to complete the DLED degree, my lord.
I see.
So their degree was
so you are TET qualified.
Yes, much prior to that. My lord, the candidature of 2020-2022 candidates, DLED candidates, have been excluded by this honorable High Court by order dated 11th April 2023.
In the appeals which were preferred.
Yes, 3 appeals have been preferred.
So appeal court order and 2022 candidates were excluded.
Yes.
Who were said to be participating on the basis of the consent?
Yes.
Next, yes.
Now those candidates challenged this order before the Honorable Supreme Court.
All right. Supreme Court said that
Supreme Court initially stayed the process, entire process.
that is stayed at the time. Now we are asking when any panel was prepared in the
No,
meantime.
at that time, no panel was prepared.
Achha. Then Supreme
They
Court stayed.
stayed. By order dated 22nd January 2024, Supreme Court directed the West Bengal Board of Primary Education to file a affidavit stating the present status of the recruitment.
Yes.
On 29th of January 2024, the board has filed the affidavit. This is the first time we came to know about the preparation of panel and we came to know about our status. In the affidavit, my lord, they have stated they have found 9,533 eligible candidates. My lord, where from they got this figure, my lord, we don't know, because the panel, the recruitment is of 11,765.
So very good. In the affidavit, they disclosed a panel.
Panel as well as our status also.
Panel consisting of 9,533 candidates. Were you there in that?
Yes, we are there in that, but in a separate category, stating unobserved category. We are the candidates of unobserved category. Before the Supreme Court also, they have submitted our details with score. We had just shortfall to some one or point, my lord. Because the cutoff marks they have stated of 9,533, my lord, were just shortfall to that. They have stated as unabsorbed. It is not the case that a prior cutoff mark has been fixed. No cutoff marks has been fixed. My lord, all of a sudden,
what happened? The affidavit was placed before the Supreme Court.
Before the affidavit was placed before the Supreme Court said, just since you have found 9,500, you appoint these 9,533 candidates with a rider that their fate should be subject to the outcome of the SLP pending before the Supreme Court. Now, in the same order, my lord, Honorable Supreme Court also directed that interview of 2020-2022 DLED candidates should be started by the same order, that is 29th of January 2024. So, based on that order, my lord, they have started giving appointments and they have also started conducting the interview of 2020-2022 DLED candidates. From 24th of February 2024, they have started the interview process. But since 24th of February 2024, we are in October 2025. But they have not come with the score of those candidates who they have been interviewed. Contrary, my lord, on 4th of April 2025, that is much after the order.
Confusion remains. In the affidavit, they disclosed that in respect of 9,533 vacancies, they have prepared a panel. In that panel, you were not there. Now, how you were shown as an unabsorbed category? Where does this come from?
That is our question also, my lord, because we never heard of any category like unabsorbed, because we are just shortfall. Our score is
9,533 vacancies. The persons who are empaneled, any person was having more marks than you.
Yes. All these persons having more marks than me. We have no grievance against them.
Marks in what? That
the total marks. The marks also been given.
Including training, test.
Yes, everything. Interview, aptitude test.
I see.
Even our score has also been disclosed. Even our score is also very good.
Very good. Now in so far the appointments which have been made, those candidates admittedly have more marks, secured more marks.
We have no grievance against them.
Very good. Now you are saying that in terms of Supreme Court direction, they are now wanting to consider 2022 candidates.
We are saying that it is there. It is there.
Now these 2022 candidates whom they are taking steps for recruitment, they are saying we will not appoint any person amongst them who will secure lesser marks than the marks secured by you.
If they
Say that,
yes,
then
then
you
our
will
grievance
enter
goes.
writ petition and appeal.
Yes,
to
our grievance goes.
Acha.
But they are stand before the Supreme Court, as I have annexed in page 261, states only about 2020-2022 candidates.
Very good, but if they say this thing, then you have no grievance as such.
Yes.
Now, what is this unabsorbed category?
My lord, I do not know, my lord. Perhaps they can say, my lord. Because pursuant to the Honorable Supreme Court direction, they conducted the interview of 2020-22
Now,
DLED
you
candidates.
also made an application for impleadment before
Yes,
the Supreme Court.
yes, that is our case. Your lordship, kindly see the order of the Honorable Supreme Court at page.
My lord, may I just clarify, my lord? My lord, your lordship has got the picture, my lord. Just, my lord, two, 3 lines, my lord, I had. My lord, when the recruitment notification was published, 29th September, my lord, the recruitment, my lord, before the recruitment notification, my lord, writ petition was pending. One writ petition was pending, apprehending that we are the batch of 2022 DLED candidate. We should be, we should get the chance in the recruitment process before publication of the recruitment notification. My lord, before the single bench, my lord, I'm sorry, my lord, kindly, my lord, excuse me, my lord. We were compelled to, my lord, include 2022 batches. Even, my lord, at that point of time, they were not, my lord, the qualified as far.
That consent order came.
Not consent order.
Yes,
Not
my lord, that is-
consent order. My lord, in the morning, my lord, we are threatened. My lord, if you do not do that, we will do these things. My lord, we experience. That is why we publish the notification, recruitment notification. We come with the recruitment notification, allowed, my lord, 2022 batches to participate in the recruitment process.
We are asking Mr. Biswas, this process which you are conducting now,
My lord,
2022 candidates you are considering.
my lord.
So, consideration of the persons who obtained that training prior to 2020
My lord, they were already considered.
already considered.
Already considered. My lord, they are candidates.
Participated in the interview and aptitude and got the final one.
Absolutely. My lord, as of today,
Sure. Which would be unabsorbed category. So that 29 January 2024 affidavit which you filed before Supreme Court
my lord,
in the panel of 9,533,
my lord.
none of these persons were there
No.
because none of these persons secured the qualifying mark.
My lord,
Cut-off
your
mark.
lordship knows, my lord, there is no cut-off marks.
No,
There is no cut-off marks.
9,500
9 and panel was prepared.
candidates, last candidate marks.
Last candidate marks. So, my lord, their, my lord, score is less than the last panel candidate. Even, my lord, today, if suppose your lordship, my lord, a candidate is being appointed, but, my lord, the batch of 2022, my lord, the DLED batch, my lord, can we appoint any person, my lord, below the, my lord, cut-off marks already appointed?
Page 243 is the observation by the Supreme Court in this matter.
Why should we go into?
But it's absolutely premature, my lord.
Because the Honorable
as well
Supreme
as
Court
the
said
appeal.
that
you are saying that if the statement comes on record that no person who have secured more lesser marks than you would be absolutely, then your original prayer in the writ petition was you publish a panel pertaining to the remaining vacancies and consider our case
in order of merit.
in order of merit. So if the instruction comes today that we will not include or we will not give appointment, then everything goes.
My lord, all we will do in accordance with law, my lord, as of today, panel expired 2 years back. My lord, as of today, no writ petition is pending challenging the panel. Your lordship, no writ petition, your lordship, my lord, will.
So you come with the statement that
Yes, I will. My lord, the very, my lord, first, my lord, I submitted, my lord. Yeah,
instruction which you are coming, you file a 2-line affidavit to that extent.
as your lordship
Plus-
desire, my lord.
so that we can dispose. There is no, because single judge said that file an affidavit. So when that direction is there in the affidavit, you make this statement and give a copy to him so that if he will check it up, if he said dispose it upon that.
My lord, since there is a direction for filing affidavit, my lord, we have to deal, my lord, each and every paragraph.
That is what I am thinking.
That is why, if
Then
your
again
lordship,
the matter goes back to the writ court.
My lord, in
my
the
lord, that
read
is
court,
why,
my
my
lord, we
lord,
are not getting
if your
hearing.
lordship,
Kindly. My lord, in the read court, my lord, we are not getting hearing, my lord.
ওটা বললে হয়?
My lord, my lord, they are already proceeded with the
Yesterday,
the
made this
appointment,
submission.
my lord, since they have got order from the
Sir,
Supreme
then
Court.
you agree to this, we will direct him to file a report in the form of an affidavit making the statement. Then he will not deal with all the allegations made in your writ petition. We will dispose of the writ petition
Only one thing, my lord. For
and we will record that he has not dealt with all the, shall deem to have been denied.
my lord, if they say that the remaining vacancies will be filled up in accordance with merit, we have no grievance.
how can I appoint without merit, my lord?
No. Let them say, because their application says otherwise.
Show us that Supreme Court what you are showing.
Page 243.
ভোটের মামলা করতে করতে না
Going the Honorable Supreme Court's direction, my lord, they are saying that this.
Don't involve Mr. Sanal. He is a senior counsel. It's not possible for him to remember everything. No, seat arrangement is right. You sit there, but he will read. Page 200.
Page 243, your lord, my lords. Paragraph 33.
Yes, place it.
In view of the above, we allow the appeals and set aside the judgment of the division bench in
Now, this judgment of the division bench was
17th April 2023.
Cancelling the consent order.
Yes.
Consent order no. Cancelling the order. That order was 2022. Will be
Exclude
allowed
these candidates.
Will,
Excluding the candidature of 2020-2022 DLED
No,
candidates.
the order which was passed by the single judge was that which you said to be a consent order. By that order, the 2022 candidates were directed to be considered.
Yes.
Against that appeal.
Yes.
Appeal said that order was bad.
Yes. Yes.
Against that, you have Supreme Court was approached.
Against that, Supreme Court was, yes.
Then place what is Supreme Court said in view of the above? Yes, place.
In view of the above, we allow the appeals and set aside the judgment of the division bench in MAT number 1725 of 2022 dated 11th April 2023. And we direct that the recruitment process which commenced in the notification dated 21st October 2022.
21st October.
My lord.
What is this 21st October?
My lord, by this notification, my lord, online applications were invited. So the recruitment process started. The initial notification is of 29 September, and this is the subsequent notification. By this notification, online applications were invited. Must proceed further, and the board must take immediate steps for conducting the recruitment process as expeditiously as possible. Now, paragraph 34. Our consideration was confined to examine the legality and validity of the judgment and order passed by the division bench of the High Court. All applications, including our application, because we have also filed implement applications there. All applications for the implement are dismissed as withdrawn. The applicants are permitted to avail such remedies as
you preferred the writ.
Yes, saying that.
So you preferred the writ, no?
Now the contention of the board is that Supreme Court by this order had stated that the remaining vacancies should be only used for 2020-2022 DLED candidates. We are saying Supreme Court has never said that.
Where did they say that?
My lord, in the division, the single bench order I have shown 17th June 2025. That is at page 256. And in the miscellaneous application.
You are master of the facts. We are just now. Let us understand. Otherwise, we will again commit mistake.
Page 254.
This was the single bench which you said to be a consent order.
No. This is a order passed in our writ petition.
Oh, achha.
Where the submission of board has been recorded that appointments are being given to the 2020-22.
Show us that.
Yes, my lord. My lord, page 254.
254.
line 4, my lord. However, prima facie, it appears that the petitioners are not similarly circumstanced like those candidates who completed DLED course for the session 2020-2022. Now, the submission of board. It is also submitted by Mr. Shanna Larnet, senior advocate representing the West Bengal Board of Primary Education, that consideration of candidates who completed DLED course for session 2020-2022 is in terms of the order passed by the Honorable Supreme Court. Now, Supreme Court had said consider their candidature, but Supreme Court had not said that you earmark those vacancies for only those candidates.
They are also not saying.
Well, they have in their application they have said so, my lord. 251.
No, no. Let us. What did Mr. Sannal say? That Mr. Sannal submits that consideration of candidates will be made in terms of the order.
Yes.
He has not said that
Yes.
you will be excluded or you will be included. No such statement.
In February 2024, they have conducted interview of those candidates. Till date, they have not published the score of those candidates, my lord. Whereas our score has been published long back.
So, Mr. Rao, we will say this. We will record their statement that yes, they are pursuing with the procedure as directed by the Supreme Court, and they are making a statement on instruction that they will not include any candidate or appoint any candidate who will secure marks lesser than the marks secured by you.
Yes.
In the event such statement is violated, you will be able to come up before us.
Yes, that is exactly our case. In the remaining vacancies, my lord.
Yes. যেটা অর্ডার করেছিল রিট পিটিশনে
2022
হ্যাঁ সেখানে গুলো 2020 পার্টিসিপেট করতে পারে তার এগেইনস্টে পার্টিসিপেট করতে পারে তার এগেইনস্টে
Kindly.
চাইছিল না বলেই তো রিট করতে ঠিক আছে
maybe
11th April 2023 order. No.
This is the division bench order at page 96.
Yes, that is the division bench order. Where is the single bench order? What did the single bench say? You were not parties to that.
No, no.
What did
The single bench, my lord, they said that we will consider their candidature.
Very good. Now, what
So in
did
a
the
4-line order, single bench
what
allowed the
did
writ
the
petition.
division bench say?
Division bench said excluded their candidature since they are not.
No, সেটা তো বলছে না।
Yes, ma'am.
Page 112. Board always intended to have to be carried the eligible
argument of the board.
which carried the eligible. Yes.
Described by the board.
এজ কত রে এটা?
স্যার 112
পার্টিসিপেশনটাকে সেটা সিঙ্গেল ইয়ার করেছিল দাও
112 ভাই
ভালো অ্যাপিলটা সাকসিড করলে এটা তো হচ্ছে বোর্ডের
অ্যাপিলটা তো
আচ্ছা হু প্রেফার্ড দি অ্যাপিল
appeal was preferred by the TET qualified candidates in a subsequent TET 2017 candidates were preferred.
Not the parties to the writ petition order 29th of September 2022.
Well, their order was shell.
Appeal preferred by the candidate other than the batch of 2020-22.
Acha, so where is this 29th September?
Yes, my lord, I am
2022?
searching for it.
So what did Justice Talukdar say in the appeal? Page 112 kindly comes to the third paragraph.
The above arguments of the board are self-defeating in as much as the court finds that the board always intended to act upon the notification dated 29 September 2022, which carried the eligibility for the writ petitioners who were not DLED qualified to apply, since their course was not completed at that time. The argument of the board cannot be also sustained, since even as on 21st October 2022, described by the board as the proper recruitment notification, the writ petitioners were DLED qualified candidates, were not DLED qualified candidates. See, my lord, in the first notification is of 29 September 2022. At that time, their course was not complete. In the second notification, by which the board seeking the online application form, my lord, in the second notification also, at the time of second notification, those candidates did not completed their course. That is the observation by the division bench. Clause 3B of the last paragraph, my lord. Clause 3B of the recruitment notification dated 29 September 2022, followed by the further notification dated 21st October 2022, to the extent of permitting candidates who did not have the minimum training qualification on the date of notification dated 29 September 2022 to apply, stands quashed. So this order was challenged before the Supreme Court.
But this appeal was preferred in a separate writ petition, not the writ petition which was disposed of by 29 September 2022.
No, disposed of in the 29 September order, my lord.
This is the appeal order in that connection with that. 11.
Yes, my lord, kindly see page 97. In MAT 1725 of 2022, এই অর্ডারটা বার করো না, রিট পিটিশন আছে।
Oh, it was hard along with that.
But the order passed by the single bench is at page 77.
দিল তো বাকি অর্ডার গুলো অ্যাপিল কে নিতে হয়েছে পলিটিক্স আছে দেখ দ্বিতীয় লস দিয়ে দিয়েছিলাম সলিউশন এবার এটাই একটা politics।
Kindly come to the internal page 4 of the order of 6th of May, the order of Justice Bhattacharya.
में खाना था
This memo of appeal kindly take up.
Yes, my lord, fourth page.
Kindly come to internal page 4. Mr. Sannal, learned senior, has prayed for accommodation to obtain instruction regarding stand of the board while filling up posts which are lying in connection with the selection process, and whether petitioners are to be considered along with the candidates who were. These are the two instructions Mr. Sannal said will furnish. So you file whether the writ are considered with the candidates. You can deal with these 2 points, saying that we will not be appointing any person who has secured marks already obtained by the writ petitioners.
My lord, it is, my lord, the law, my lord. If I, my lord, do that, my lord, can I, my lord, contrary to my rules?
দিলেও চ্যালেঞ্জ করবে তবে তো তোর আরেকটা রিট পিটিশন হবে
দরকার নেই স্যার এমনি পকেট থেকে দিচ্ছি
বললে হয় বিকাশ দা বলে আমি পয়সা পাই না ও বলে কি মামলা করছে ভাই এত পাগল রে ছাড়ি দিচ্ছে আমাদের নাকি প্রিম্যাচিওর
হ্যাঁ, absolutely premature. একদম বাড়ি হয়ে গেছে।
My lord, they are saying that they will take instruction. On 13th, 17th, they came back and said they showing the Supreme Court order. The Supreme Court had said to proceed with 2020-2022 DL. Supreme Court has not said so. My lord, I have just now shown your lordship, my lord.
And they have said that we will file an affidavit to that.
My lord, they are not filing the affidavit. My lord, more than 4 months has been back. My lord, it is the order of June. My lord, they are proceeding with the appointment since they've got order from the Supreme Court that within 6 weeks they will appoint 2022 DL candidates. Within 6 weeks, that order is of 12th of September 2025. My lord, I have annexed the order. The Supreme Court has not said that only appoint on 2020-2022 DL candidates. But if they secure less marks than me, my lord, we are not praying for reconsideration of our candidature. But we have given interview. They have given interview, my lord.
Sir, only that's the limited apprehension of yours.
But apprehension.
If person securing less marks than you are appointed, that's your only apprehension.
Apprehension based on the application filed by them before the Supreme Court, page 261. They have stated only about 2020-2022 DL candidates.
Actually.
That is the, yeah, if they say that we will fulfill the remaining vacancies in accordance with merit, we have no case. Let them say so. Because before the single bench, they said otherwise.
What, that they will put people with
yes
less?
Before the single bench matter, affidavit was called for, my lord, only on the based on the submission of Mr. Sannal that they will the Supreme Court had said so to appoint 2022 DLED candidates. Supreme Court only decided their candidature. Not said. But if they secures less marks than me in the interview and in the total, how they will?
Where this Mr. Sharnal has
Believe me,
said, he
Twitter.
has not said
Well,
that.
my lord, my apprehension for my sake, my lord, kindly see their application before the Supreme Court.
Apprehension can be interfered.
No, since my lord, affidavit has been called for by the single bench, let them say, my lord, in the 2 lines affidavit before the court that they will recruit candidate on the basis of merit, my lord. We have no case. Since that has fallen from your lordships also, my lord, kindly, my lord, let them say, because there is other order also, my lord, where the Supreme Court said appoint these candidates. They are not considering their candidature also, my lord. Before the court of honorable chief justice, the NIS candidates have got order in the meantime also. They are not considering their candidature also. They have conducting the verification process long back.
We will record that and we will direct incorporating that instruction. You will file an affidavit before the single judge. Or if by virtue of that, if that is if he satisfied on the basis of your written
Well, he will
instruction.
never satisfy, man.
Eh?
He will
How
never
can he say
satisfy.
that?
Today he is saying that.
Well, kindly see the
before us.
What
Kindly
he
say
is
their
asking for,
submission.
he is asking for merit. Election appointment according to merit. Well, record that board will proceed in accordance with law and the rules. Merit means rule.
Mr. Shandal, we want to solve the issue.
Yes, my lord.
There's
Kindly.
nothing to be solved. Unnecessary this litigation before your lordships.
No,
What is the dispute before your lordships?
Dispute is
Has he been shown? Has he been able to show that we have recruited without merit?
how he can show, because he
Panel has been published.
was expecting the instruction to come before the writ court.
But expecting to what?
17th of June order.
Exactly, your lordship.
So why he didn't to file the affidavit? You prompted filing of the
Oh, my lord, has it been taken up thereafter?
which one?
The writ petition.
Irrespective of that, you have
There is
not
a
filed your
direction,
affidavit.
yes.
My lord, affidavit.
You had filed the
Affidavit is
Mr.
filed
Sharma.
when the matter is taken on the board.
No, Mr. Sandal, you cannot say that.
So that's
It takes
taken.
3 weeks time was.
We will file it within a week. Let the single judge take it up within a week. We'll file it. Do that, your lordship.
We are saying
In a week, according to this order, we'll file affidavit. Kindly request the learned single judge to take it up immediately. Hence the matter.
Hello. Well, once for all, let it be placed before your lordship. We are saying that we will not proceed with the writ petition if they say that the remaining vacancies will be filled up according with merit. Because they cannot change their stand before the Supreme Court.
So
They say
that's
something
my lord.
else.
Every day I'm saying your lordship take up the writ petition. Your lordship is never taking up. Yesterday I also took up. Please take up the writ petition to avoid these litigations.
Kindly see their submission before the single bench is at page 77. It's a consent order, my lord. They are favoring 2020-2022 DLA candidate.
77. Not kindly see the very first language. I was told whatever certain things untold, not recorded. Kindly see the very first language. I didn't appear. I do not say anything. Kindly see the first language. Everybody is embanking upon that court's order. I was told. Certain thing was told, but not untold in the order.
How you became so silent before that court?
Man, I didn't appear in any of the matter because I was told by the learned judge, you don't appear before me. I never appeared in any of the matters.
Lost the chinta.
I mean, within a week, I will file the affidavit.
Yeah, we are asking you,
Everybody,
proceedings with law, very good, but with a rider that there will be no such appointment who have secured lesser marks than it.
certainly, your lordships, we cannot.
That line you have to put in, otherwise the litigation continues.
My lord, kindly record that affidavit in this line, in the line of the learned single judge.
Yeah.
Internal page 4.
Ashok, the present appeal has been preferred.
14 and 15, they arise out of the same order. 14 is at the instance of the college who was the writ petitioner, and 15, my lord, leave was granted by the Honorable Division Bench, my lord, the coordinate bench, in item number 15, permitting the students who are likely to be affected
Yes, sir.
permitting the students who are likely to be affected, not to file an application under leave to prefer application for leave to prefer an appeal. The leave application has been allowed. They have been permitted to prefer an appeal from the Honorable Single Judge's order, whereby, my lord, interim order was declined.
So where is that? Oh,
That is item number 15. In item number 15, my lord,
that is 1762.
yes, there are two appeals. One is 1761
That is item number 14 is 61
and 1762. Yes.
University refused to register them.
Yes. What has happened, my lord, here is these.
Who is for the, you are for
My lord, I am appealing for the university. I am for the appellant student.
College was the writ petition.
for the students.
I am for the students, man.
Led by
I am
Mr.
for the student.
Mujumdar.
I am led by Mr. Mujumdar, madam.
Now, today,
But what interim order did college think?
that the college sought for allowing the students represented by Mr. Shaumo Mujumdar to appear for the forthcoming examination. The Honorable Single Judge,
When is the examination?
that today, the date after the appeal was filed, the date has been notified to be 11th of November 2025.
Of November.
Yes. Now, the only thing is, if I may show your lordship, my lord,
But you sought for consideration of the present.
no, with in the writ petition. No, I'm sorry. No, maybe I am wrong. No, just
They are the page 50. Consider and dispose of the representation.
yes, that was one of the representation. And then, my lord, the next prayer may kindly be also looked into.
Cancel the ODR from taking effect.
To any order or by which the registration in respect of 41 students in the course of PB, BSc nursing in any manner whatsoever.
Has been withheld.
ODR from taking effect to registration of 41 students.
To the decision not to register.
Cancel
Your lordship is correct. There is a typographical error.
Withheld kothata.
Forbear to give any effect and not further effect.
Any such order was passed?
No. What was done is, I am indicating to you. Since your lordship invited our attention to the writ petition, my lord, please take the trouble to come to, my lord, my lord, yes. The college is running a nursing course. PB BSc nursing is a post after BSc nursing. It's a diploma, post basic BSc nursing course, for which, my lord, the college, admittedly West Bengal Nursing Council, the university, all has granted a 60 student intake. I should be very honest. Indian Nursing Council, 30 has been sanctioned. 30 inspection is even going on today for the balance 30. But we have the recognition from the university in respect of 60 and in respect of West Bengal Nursing Council 60.
Entire bulletin is.
We were running the course.
There should be an allotment.
What happens is,
How many were the students? 41.
Total, my lord, total 60 students have been admitted. Yes.
41 came.
41 came by way of a leave to appeal. They did not come by way of writ petition.
So how many years?
2 years. The course is of 2 years.
Diploma course.
Diploma.
So
Now,
there is an eligibility for participating.
yes, eligibility, my lord, the West Bengal Joint Entrance Examination Board conducts the examination. All the students who have been admitted in the course have been routed through the West Bengal Joint Entrance Examination Board. They have participated in the West Bengal Joint Entrance Examination Board selection test. Is known, there's a particular name given to it by the board. My lord, 19 students through counseling were admitted. Seats remained vacant in accordance with a previous decision of the government of West Bengal in 2023, whereby, my lord, these vacant seats were allowed to be filled up. Anticipating a similar decision in 2024, my lord, the college, from the students who participated in the joint entrance examination and who have a particular rank given by the board, but not routed through the counseling process, not those students were admitted within the cutoff date earmarked by the Indian National Council, the Nursing Council. Today, the issue is when the examinations came, the university has admittedly taken money from us for each student. That is, of course, neither here nor there. That is neither here nor there. The university has also indicated in one of its communications that they are going to provisionally register 30 and allow 30 to appear in the examination. University has indicated by way of a communication addressed to the college from the registrar's office that they are going to register 30 students for the present, and the balance 30 they are going to provisionally register so as to enable them to appear in the examination. Now, the documents which are a part of the records were shown to the Honorable Single Judge. His Lordship felt that since the examination was on that day when the matter was moved before the Honorable Single Judge, that was the first day after vacation, after the Lokhi Pujo, first vacation, when the matter was moved, there was no date fixed by the college, by the university. His Lordship felt that in the event the examination is held in the month of October, then these students be permitted. In the event they are not, then the matter be placed before the regular bench. That was the order. Assailing that order, we prefer an appeal. My learned senior friend also carries an appeal to the students. On that date, on both the dates, in fact, it is the Indian Nursing Council which refers to a previous order passed by a division bench of Your Lordship's court, saying that no equity can be granted to students who are, according to the Indian Nursing Council, have been illegally accommodated. The issue is, here there is no lack of qualification. There is no such issue as to
Allow them to appear provisionally. The examination is in month of November.
Today it is in the month of November when the writ petition was moved.
Petition is contradictory to the first degree.
No, it was passed because the court was impressed that what if the court is not in session and the examination happens. Under such circumstances, this order was passed that if the examination is in October, you will be allowed to sit. If it is in November, the court regular
Court cannot.
right court says the regular bench will adjudicate the issue whether you are entitled to sitting or not. That was subject to correction by my.
Your reading.
No, my learned friend was also there. If I'm wrong, he will kindly correct me. কি তাই তো আমি ছিলাম, আপনি ছিলেন না, আপনি শুধু পুরো বোঝা যাচ্ছে না।
So, Mr. This prima facie appears to be contradictory direction.
True, that was my learned friend also says, I'm right. So my lord will kindly consider me.
Allow them to participate.
It cannot. We cannot. I'll
First of all, just before my learned senior friend takes over, for the students, only one page I need to show your lordship. Please see page 245.
But Mr. You have not preferred appeal against.
No, I have not.
Accepting the contention.
It is not in October. It is not in October, so no question of now the court has to adjudicate. The examination did not happen in October. They're in November. No interim protection they have. I need not file an appeal.
2025. Kindly see.
Your understanding that if it is the court's order.
Of course, the court says if it is in November, let the matter appear in the regular bench.
My lord,
University month of November, let it happen.
Let it appear for the courts to consider.
However, if it is in October, all should be allowed.
Because the court is not in an opportunity to hear out the petitioner.
It was an opportunity to.
Milord, my learned friend was there. My learned friend will kindly also apprise the court as I am apprising. Milord, we did not have any hesitation understanding what was
page 245.
Universities.
My lord, I'm appealing for the university. My lord,
this 245, this mail, which talks about 60 students, does it include the 41?
41, yes.
So then what is the problem?
Problem is, Milord, they are not doing this. They have only registered 90.
60 has two parts. One is 30, as your lordship has already.
Let him take over.
That segregation will be a problem.
So out of the first 30, 19 have already been
registered.
So the rest is 11 out of 30.
Correct.
So 41 includes this batch of 11, and the rest is 30 who can also be directed to be provisionally appearing without prejudice to anybody's rights or without treating anybody, because it's knocking on the door. 11th is the examination fixed, I am told.
I'll take 5 minutes from you, Lord.
Order of page 245. This is a request for date of admission.
Verification of post-basic BSc nursing.
By the university.
Yes, registrar.
As per the order, 60 students have registered for post-basic BSc nursing.
The order means which order?
But it refers to some correspondence between government or some.
Students have registered for post-basic.
Out of them, the first 30 students will get registration number as per the admission date, and the remaining 30 students will receive provisional registration number.
Why?
This is probably because what I find from one of the documents in an earlier round, in the earlier year, that they had fixed. No, this could be because of the enhancement of seats, which is under consideration.
152 may kindly be looked into.
Under whom you have conducted the course through these colleges.
All the
Chatterjees for the
Indian Nursing Council.
I'm the regulatory body.
Conducting the examination.
No.
Who is conducting?
INC has a statutory duty to only to lay down the standard of education.
my lord, the examination is conducted by Joint Entrance Board, who is not a party.
Just a minute. The admission procedure should be regulated by the state government with the state nursing council under the statute.
But you have not made the joint.
They had conducted the examination. That's all.
Well, may I indicate, my lord?
They are
No, my lord.
the university.
I'll point out, my lord. Let them complete.
Well, kindly give me 2 minutes.
Let us understand what is your case, what is your case.
But we are all registered nurses.
Registered with whom?
With the state council, state nursing council. We are all registered nurses. We wanted to enhance our qualification. That's why we want to pursue this course.
Wanted to enhance your qualification.
Now, this course entails serving the government hospital for a period of 4 months during the entire course period of 2 years. This is done on the basis of understanding or an arrangement made between the government hospitals, the government, the colleges. But we had done for the first year, we had concluded this training program or service for 2 months in various government hospitals, be it psychiatric, be it orthopedic, be it pediatric, we have done this. But we have also paid the registration fees in January 2025 accepted by the university.
2,500 each.
Yes.
We had all passed the necessary entrance examination for this purpose before we got ourselves inducted in the course. There was an entrance examination.
Entrance examination conducted by
the West Bengal Joint Entrance Board. Many of the states don't follow this examination. West Bengal does have a process for conducting the examination. We have participated therein and ranked therein.
We had
given the choice colleges for the purpose of counseling. 19 had been counselled. In the midst process, there was a cut-off date for admission. There was no such counseling thereafter. So, in terms of earlier practice, the college had admitted these students from the rank list.
So, what is the total? 19 completed counseling.
Find out.
And what was the remaining? Who did not?
41. 11 out of the first 30 and the balance 30. So, 41.
41 plus 19. Total?
No, 19 plus 30. 11 plus 30. 11 plus 30. 19 already inducted and registered.
Yes, 41 plus 19.
41 plus 19 is total 60.
Now, this counseling was attended by 19 persons.
By 19.
And then what happened? Counseling?
Then the counseling did not carry on further. The last
counseling was conducted by the West
Board.
Bengal Joint Entrance. So they are in the queue.
They are in the queue, in the rank list.
Rank. So you are representing how many persons?
This is 41.
Who have not completed counseling.
Now, page 245 is a document generated by the university sometimes in August 2025. 18th August 2025.
Yes.
May I place that page? As per the order, 60 students have registered for post-basic BSc nursing. Out of them, the first 30 students will get registration number as per the admission date, and the remaining 30 students will receive provisional registration numbers.
Irrespective of counseling.
Irrespective of counseling. Kindly verify the admission date of the first 30 students and send the admission letter as a supporting document.
This is addressed to whom?
But this is a request for, this is by the University Health Department to the principal of the college. University to the college.
This was 18th August
25.
Then what happened?
But we had in the meantime from November 2024, we had pursued our courses. We have served the government hospitals for each of those months.
You have pursued since November 2024. The 2 years diploma.
2 years. Post-basic training. Post-basic BSc nursing program. I'm not the two questions may fall for consideration in a larger issue, not whether INC can at all regulate this admission process in the absence of regulations framed. which is statutorily required to have a legislative supervision. Number one, it can't be done through an administrative act or an order. That's the requirement of the Indian Nursing Councils Act. Number two, if there is a conflict between Bengal Nurses Act 1934, whether there is at all a conflict between the Bengal Nurses Act 1934 and the Indian Nursing Council Act 1947.
What is their stand? Why they are opposing?
They are opposing probably on the ground that they have not been admitted through a process of counseling, although they had passed the examination and had been admitted before the last date of admission.
Indian Nursing Council is opposing such.
Yes.
So have they put it on letter?
No, nothing. Now, the college filed a writ petition to expedite the process of registration of the students because the examination was knocking at the door.
Then what happened to
Then that order was passed by His Lordship that if it is in October, then provisionally allowed to take the examination. If it is in November, no provisional allowance.
You have told the single judge then.
No,
then
we
you
were
are
not
satisfied with the. Then you are satisfied.
That's why we came up. That's why we came up in a leave to appeal before the Honorable Division Bench.
Mr. Bhattacharya was there.
But he appeared for the college.
In fact, in the writ petition, which my learned senior friend is showing, the writ petition contained all the documents apart from the students coming up. Only the college came.
No,
The college was espousing the cause of the students.
Mr. Bhattacharya, what was the reason for not saying this to the court? That if it is in the month of November, you are not partner.
Yes.
Then you will get a fora. But if it is month of October, you are.
That is what the I cannot say anything beyond that. That is what paid with the honorable single judge.
We are trying to understand that because Mr. Chatterjee says consideration was when the court will reopen, get an opportunity of getting. Then, if it is no opportunity got, then you should have.
True. Today, it is after filing of the appeal.
Since may I just put it
yes,
for kind consideration. 11th of November is the date for conducting the examination. But if the arrangement postulated for October could be extended provisionally, His Lordship has extended an arrangement, had made an arrangement for October.
But that order will, how will it suffice? Because the party who will allow you to participate is not here.
Yes.
University.
But this order is also passed in absence of the university.
It is the university.
This was passed in absence of the university.
West
Bengal Joint Entrance Examination Board's role ends with the process of conducting the selection.
It's an agency of the university.
Yes, nothing else.
They conduct the counseling.
Everything.
And they recommend X, Y, Z to various colleges. The counseling here did not reach a stage enabling the further admission. It stopped with 19.
Why? What was the reason?
That no one knows.
Verifying.
Now, since it is my duty, my lord, appearing for the college, to show your lordship page 152. You see, there was a previous decision in 2023 permitting the college to fill up these vacant seats. Anticipating a similar decision, my lord, the college.
So that is of the director of health, not by.
Yeah, but please, not by no. Mr. Chatterjee never opposed. Mr. Chatterjee in 2023, or I'm not Mr. Chatterjee, I'm sorry, his client. His client did not, my lord, act like a spanner in the wheel, my lord, in preventing this. My lord, please see page 152 for a moment. This is for information to all concerned that after completion of counseling by Joint Entrance Board 23, a huge number of vacancies in BSc Nursing, post-basic BSc Nursing, this course, GNM are still persisting in non-government. Now, in order to fill up the vacant seats, candidates having rank either in such and such having domicile will be allowed for admission in non-government institutions to fill up the vacant seats in BSc nursing courses. However, they should fulfill the minimum eligibility criteria, etc. Vacant seats for post-basic BSc nursing in non-government will be filled up by candidates appeared in PBN 2023 examination conducted by the WBJEB. Anticipating, I indicate to you a lot. This was of 2023. The same situation cropped up in 2024 after the 19 students counseling got over. And through counseling, 19 students took admission. They have no quarrel with 19. The balance 41, 11 and 30 is an issue. We have
why you are segregating 11 and 30?
Because they have said in page 250, 45, 30 and 30.
So the first 30 get registration number.
30 is the already sanctioned strength or seat. It is being enhanced to 60.
And we have documents from which
how the counseling will start again.
The counseling will not. Admission is over.
Then what will happen to those candidates who are getting admission without counseling?
That is page 152. In 23, this was permitted, and no one raised any issue.
There is no possibility.
Absolutely. Today, there is no such similar decision like 152 for 2024. Correct. Your Lordship is 100%. I cannot have two views regarding that. I cannot say anything. But factually, what happens is these seats remained vacant after 19. After 19 council students
approached the court.
When was the counseling done?
Counseling was done in last year.
September, October.
October 24.
The issue has been decided. Manuel, kindly give me
The
one.
issue is, I'll come to the issue which has been
So
decided.
far as regulating admission is concerned, I can go to the extent of submitting that INC has no jurisdiction.
Absolutely.
They don't have.
Well, I'll accede to that.
But we are wanting, you should have been agreed at that juncture. The counseling was.
In January, the registration fees were accepted.
Maybe you then.
Not them, not me. College. They are admitted under me.
Registration has to be done by the university. It's not the INC which will register. We are already registered nurse.
No, counseling registration will come subsequent to successful counseling. If the counseling is stopped after 19.
Grateful, Milord.
Consider 19.
Grateful.
Admission, then registration. Admission, then registration. Counseling has not been regulated through a statutory regulation to be a precondition.
Counseling was conducted on what basis? Was there any?
No, it's not. It's a choice of colleges given. More than 49 or 5,000 seats still lying vacant. Not a nurse in Murshidabad is not giving a.
My lord, that is my stand. My lord,
that is the stand.
That is the stand, my lord.
They have said anything else.
Space 240.
Yes, and Milord, apropos our email made, Milord, that is referred to in the order impugned.
That is 245 is pertaining to registration.
Yes.
Not participation in the exam.
But then, Milord, we wanted them to expedite it by
Registered student
Only
can
we
sit
allow.
in the examination.
My lord, if I may clarify, my lord, I am
Probably not like that medical.
No, may I take 1 minute before that, Milord? Milord, it is not that INC is, Milord, trying to act like a spanner. But at times, Milord, the sanctity of the procedure has to be preserved. That is of much significance. My lord, this is admission to post-nursing courses. These all students, my lord. Admission to post-nursing courses, my lord, the admission is by virtue of an entrance examination conducted by the West Bengal Joint Entrance Board, my lord. Now, my lord, this mandates that every college should admit students on getting an allotment letter from this board.
Counseling is
My
also
lord,
done by
the private college here in my lord, counselings, my lord, from the petition, my lord, will find the counselings had happened on numerous occasions. Thereafter, it stopped. My lord, about 5,000 seats were vacant. My lord, the college did not approach this court that allow us to fill up. My lord, the allotment letters are given in terms of merit ranking, my lord. Allotment letters issued by the board, my lord, are given in terms of ranking. Now, my lord, college goes to admit student on their own without any. This is, my lord, one of the patent illegal admission that I'll say, my lord, because they admit students on their own. For what consideration? A student is admitted without an allotment letter from the conducting board. We do not know. They admit students. They admit all students.
Admission also is first an examination, then counts.
Absolutely. And my lord, several round
Examination, they
participated. All students participated in the examination. All
secured, they emerged to be successful.
my lord, everyone.
Examination was conducted by the board.
Now, my lord, everyone. I'm sorry, my lord.
What is the procedure for that examination? That the document is here. That the first there has to be a written test.
Absolutely, absolutely. It is there.
They have completed the written test and come within the zone.
Right.
যেই participate করবে
No.
তারই একটা rank.
Everyone, Lord, I'm told everyone and anyone who participates will get a ranking. Only an allotment letter will decide if the student is entitled to a college and a particular college in terms of their allotment letter. Nineteen, 11. Well, the issue.
30, no? So he 19 and 11 comes to 30. And you are representing the other 30.
No. 11 plus 30, 41. 11 plus prospective 30, that is 41.
Together with the above 30. Together with 30.
Similar issues, Millard, are pending. Before this matter was approached during the vacation bench, similar writ petitions are pending, heard by the concerned single judge numerous times. No interim order passed, because we could impress upon the bench that these admissions itself are bad. Millard, I have judgments of the Supreme Court which says, Millard, the eligibility criteria here, Millard, having the allotment letter is one of the eligibility criteria, because the admission process mandates that. True. Millard, on this, Millard, interim order.
Satisfy us how this was permitted. Let us see what is.
We may only indicate
an illegality on the part of Mr. Bhattacharya.
True. Millard, the students, Millard,
Not, I will take it.
Millard, the students also, Millard, I'll say.
My lord, if I may clear.
You are so impatient, sir.
My lord, it's not permitted by us. That's what I was trying to.
Millard, the students also, Millard, students also with their open eyes have read the brochures, which says, Millard, the without an allotment. I'm sorry.
11th.
Millard, the
Any other appeal?
Millard, one is decided on the same ratio. One is decided by Justice Sain's division bench.
Sir, out of that
I
is a
did
different
not,
matter.
I did not interfere, my learned friend.
Yes.
I have come. May I only indicate? May I act, Tarao?
Yes, yes.
Well, I did not interfere, my learned friend. This is not done.
He's helping us. He has taken the money, so impatient.
Milord, what is the case made out? Case made out is, Milord, by the petitioner. What is the case made out? Case made out is, Milord, previous. Your Lordship is going through the judgment, Milord. Milord, what is the case made out by the appellants? Appellant's case is, Milord, in previous years, after this third or fourth round of counseling, there used to be mop-up counseling. And the state has allowed the colleges to fill up the vacant seats. It is admittedly in this case, the present case, the appellant says on the basis of presumption. Thus, this year also, similar proposition or similar opportunity will be given to the colleges that even if there is no mop-up round,
But the state is a party.
Yes, yes.
Huh?
I am ready to the state.
So, you have taken any, you are contemplating any steps similar to page 240?
it cannot be. Today, Milord, it cannot be. Why, Milord? I'm sorry.
In terms of which is that page?
Page 152.
152? Any such contemplation is there? 152?
No. Second volume is
That as regards that mop-up counseling, etc., is government in CC with that sort of a consideration?
I will take instruction notes. It would not have not taken any instruction.
You ought to have taken it by now because 11 is.
Instruction will come.
Indicate this, Milord. Today, Milord, they cannot extend. Why I say this, Milord? The INC, Milord, has fixed the last date of admission.
We are not saying that we will allow. It is a question of provisional participation in the.
Milord, I'll say, Milord, in the previous round of litigation, Milord, the colleges, Milord, the facts were different, but the ratio was let down will be applicable. Milord, facts was in the previous round of litigation that the INC mandates 50% in the entrance examination. INC mandates. Now, in the previous years, state has reduced this 50% to even 0%. 23, 24, 22, 21, these sessions, State of West Bengal has reduced the percentile below this 50%, even to 0. So, Milord, in this appeal, what had happened, Milord, the colleges, based on the presumption that this year also it will be reduced, admitted students, they have done so. And, Milord, the colleges have admitted the students. Now, Milord, they were not given the registrations, like this case also. Milord, the matter appeared before the Honorable Single Judge. Milord, interim order was passed. Milord, in favor of appeal was finally decided against an interim order Milord, which says, Milord, on the basis of, Milord, presumption that this year also the marks will be lowered, could not have done so. Milord, the court observed.
They were denied participation.
Absolutely. And, Milord, the court observed that there are 5,000 seats. The state ought to have taken some steps, but as on date, it has not taken any steps. Nothing can be done. Milord,
So the ultimate
what
steps are taken, then it can be.
Milord, it could have been done had the steps taken in the month of before, Milord, November.
That instruction.
Milord, I say, Milord,
Come with that instruction.
allow me 1 minute on this. I need to clarify this, Milord. 1 minute, Milord. Today, Milord, even if the state comes and says that, yes, we'll conduct the counseling again, from the stage of counseling where it was left, we'll conduct it again. They cannot do it. They cannot do it because the last date of admissions, these admissions are illegal. Last date of admissions was November 2024. And the Honorable Apex Court has held that in nursing matters, the last date of admissions cannot be deferred. Well, kindly take paragraphs 16 and 17 of this judgment. Should I place before your lordship, Milord?
Paragraph 16 and
Page 7. Facts, Milord, I have stated, Milord, the state did not lower the marks percentile, and the college, based on the presumption that, Milord, this year also, like previous years, the marks will be lowered. Milord, the colleges had admitted the student. Should I place before your lordship, Milord?
Mr. Chatterjee, that situation will here the counseling was done in respect.
Counseling, Milord, done, but the allotment letter. Milord, counseling, if you participate.
Say that counseling you did not oppose at that juncture. It is not a case of reduction of the percentile.
No, it is not. It is not.
It's a case where 19 counseling was done for XYZ reason, remaining counseling was not conducted. Taking advantage of that, further admissions were made in lieu of money. You are on the issue of regulation. Incompetent person should not enter the course. But
No, Milord,
take of the college was.
Milord, I am on the sanctity of the system. Milord, it says, Milord, it says, Milord. True, Milord.
Your argument is that you should not dilute the admission process by creeping in elements who are incompetent. Here they 19 were counseling.
Milord, the
University said that yes, provisionally we are registered.
No, if they register, I don't have any problem.
No, my lord.
If they register, I don't have any.
Opposed to that, my lord.
What is your stand?
My lord, university is the authority who are opposing this thing. When this my lord, I'll come to that, my lord. My lord, this examination and the counseling process was conducted by the Joint Entrance Board, who is not made a party here. Much after the counseling process and after the admission, we came to learn that they.
In November 2024.
My lord, the admission was still November 2024. By then, the university was not aware. University came to learn about this admission, illegal admission, in 2025 March, April, when they find.
Why did you issue this letter, sir?
My lord, there's a typographical mistake in this letter, which was clarified by the university, and this is the only letter. There are other colleges even who are similarly placed. My lord, I'll say. My lord, I have taken instruction in the respect of this letter. When this letter was issued, the university was not aware that this administration and this registration of these candidates were illegal, because the university was yet to verify their documents. And my lord, in August 2025.
Have you got a corrigendum to that?
My lord, the university is supposed to issue a corrigendum that is the instruction which we have received.
You have already given 2 months time. 1.5 months.
There is a typographical mistake from their end. They have stated that the 60 students have applied for registration. It's not that have registered, have applied for registration. Instead of 60 students have registered. So anyone can apply for registration.
As per the order, which order you are saying?
Is their internal order?
The order referred to in this order. You are the council. You are appearing for them.
My lord, is there internal order which they are saying, my lord, on basis of their order, departmental order.
What you have said, 60 students have registered for post.
Have applied for registration. They have applied.
Out of them, 30 will get registration. So your decision has been taken. 30 will get registration irrespective of counseling or not.
My lord, no, my lord, it has been clarified, and which the university will issue a corrigendum that the registration will be provided as per the allotment letter. As per the allotment letter, the candidates.
Why this is issued by your registration section?
My lord,
Mistake.
my lord, there's a mistake, and which the university will rectify, and this is.
So students, sir.
My lord, no registration was ever provided. My lord, such letter was issued, but when the university verified all the documents of all these candidates, university came to learn that the admission was illegally done. My lord, this. My lord, by that, because they do not have any allotment letter. My lord, anyone. My lord, I'll explain the process. My lord,
Answering the query of the court.
My lord, give me a minute's time.
Read about the bush. We are asking a question to you.
My lord, I'll explain the process how it is done, my lord. My lord, there's a registration portal. Any candidate can fill up their registration by paying a nominal fees. My lord, all these candidates who were illegally admitted in all these colleges, they have paid their fees and applied for their registration. Once they apply for the registration, the university is supposed to verify their documents. Without making any verification, they have just simply seen that all these candidates have applied for registration. My lord, when university started verifying their documents, the university immediately came to learn that these candidates had taken admission without any allotment letter. Only 19 candidates of this college have taken admission after going through the counseling process. My lord, if my lord takes up page 65 of their petition, even my lord will come to. Disclosed in their petition itself, my lord, that clearly shows that the candidate needs to go through.
Types of students like
My lord, we have not provided any registration. My lord, that was before verifying the documents. After.
Who will have the responsibility?
Because they did not receive the registration.
You are writing a letter. You are saying that I will issue a corrigendum 60 days thereafter.
My lord,
you are a university.
My lord, my lord, when we came to learn.
To be here at 10:30.
My lord, if my lord grants me.
10:30 he will be here.
My lord, without.
Lives of people in this fashion.
My lord, they had taken. Back then we.
They are criminals. You are a statutory authority.
My lord,
You are doing these things so that this confusion can arise.
My lord, if I may say, my lord, we were.
You are responsible persons. You are acting in a fashion. You are acting in a manner that you write a letter in August, and when the litigation begins, you will come with the state, and you will jeopardize the stand of the council. You jeopardize the stand of the state. All of you are linked in this.
My lord, if
you are linked in this. All private understanding. Yes, college, you are registered. You register. Let them go to court. Then we will say we will issue a court.
My lord, we are the authority who are opposing this thing from the very beginning, my lord. My lord, my lord, back then, my lord, if I may say, that's an open portal. Anyone can go and apply, but it is the responsibility of the university to verify their application.
Responsible authority.
My lord, after verification,
you are a responsible authority.
My lord, yes.
Know that anybody can register by virtue of the portal. When you are aware of this fact, when you are aware that there may be corruption, when you are aware that there will be an underhand dealing with the college and the students.
No, my lord, after.
When you are aware that on the portal anybody can register, still you are registered with letter that 30% registered, 30 you are provisional.
My lord.
Huh? What is your explanation?
My lord, if I may say, my lord, back then when this letter was issued, my lord, the candidates, my lord, their documents were not.
You will destroy the state.
My lord, the documents.
You people will destroy.
My lord, I absolutely bow down. My lord, the way they have conducted the admission, they have compromised with the merit of the entire examination process. My lord, my lord, my lord,
By knowing full well that
my lord, we are the only authority who are standing in the way. Once you,
letter page 245.
my lord, this letter, when this letter was issued, the documents were not verified. When we completed our verification,
Produce your files that after this you were issuing a corrigenda. Produce your
my lord, once we came to learn, we did not provide them with any registration.
18th August will issue a letter. Anyway, no use arguing with you.
My lord, it is the responsibility of the Joint Entrance Board to provide them with an allotment letter. Anyone who has a allotment letter, the university can provide registration to those bearing the allotment letter.
Okay, sure.
Any further petition pertaining to the same?
Many,
My lord,
three,
many.
three to five at least, has been heard by the Honorable Single Judge at least 5 times. No interim order passed because, my lord, the court is seeing that the admission per se are wrong.
And for the respondent number in all the appeal.
Why? What is the issue?
For writ petition disposed of by a firm common order.
Common order. What was the challenge in the writ?
Well, there are 4 writ petition. The first writ petition, what happened in this matter, well, allegation was leveled against the petitioner that he obtained job by producing a forged certificate, forged age certificate. Number pursuant to that, a criminal case was initiated. He was acquitted in the year 1999. The said appeal went up to the High Court. Up to High Court, he was acquitted. Ultimately, in 2013, pursuant to a complaint lodged by a third person, the DIS of school directed the school authority to terminate me from my service. Directly terminate me from my service. Challenging that order, a writ petition was filed. During such time, the DI withdrew that third letter and
All right. Then all are pertaining to the same episode.
same.
So show us place the impugned judgment.
Yes, my lord, impugned judgment, my lord, volume 4, my lord, page 659. লাগবে। Lord, another appeal was there that was not listed today in the matter. That is, my lord, MAT 182 of 2022. That was filed by, my lord, the one Sekhar Manna, who is the local villagers of the writ petitioner respondent. That matter was, my lord, by mistakenly, my lord, not in the list, my lord.
That was also
Yes.
also challenged.
Last occasion, my lord, they were represented.
It has not been listed.
No, my lord.
So you didn't tell us.
My lord, today just.
He is a party in these proceedings, in the appeal. He was the private respondent in the writ petition.
No.
Person.
It's not appearing.
No, my lord. In the previous occasion, you also heard the matter on before vacation, before Puja vacation, my lord, 18th September. Kindly see the order, my lord. In the said order, my lord, in the MAT 182 of 2022, my lord, that was clubbed with those matters, my lord. Yes, that was mistakenly, my lord, not in appears in the list today. And my lord, in other way, my lord, the other persons, those are, my lord, willing to participate in the present
182
proceed.
was there.
Yes.
They are along with all the appeals. Then there are 5 appeals.
Yes.
Five
4 is filed. Yeah, 4 is filed by, my lord, the state.
No, that the 182 was also disposed of by this judgment.
Yes.
ঠিক আছে, আমরা record
All are the same.
না, যদি আজকেই হয়ে গেল তো হয়ে গেল, আজকে যদি অর্ডার দিতে ওইটা আমি লাইনটা
My lord, page, starting, my lord, page 659, volume 4 of the, my lord, paper book.
just place it.
My lord, date, my lord, 13/12/2021, my lord. 4 writ petitions are taken up analogously for consideration by this court in presence of the learned advocates representing the writ petitioners, state respondents, and the private respondent. However, Lakshmi Abhinava Vidyalaya, for short, the school has been made party, but the said school is not represented today before this court. In all the 4 writ petitioners, Vidyadhar Mandal is the writ petitioner.
School, that is the school who preferred 180.
Yes.
The school has not preferred.
The local villager of the respondent writ petitioner, namely Shekhar Manna.
Has been, who has, however, Lokhi Abhinav Vidyalaya made a party. So for the villagers, nobody appeared.
In the writ petition, they have appeared.
So that writ petition.
Kajol Roy. Kajol, no, the what happened, my lord, I preferred for writ petition. In the writ petition,
Petition was by.
no, four writ petition filed by me. The entire.
Why he is saying 182?
Yes, but why I'm saying, my lord, he was the private respondent in the writ petition. Since he lost the complaint against me, alleging that I obtained the job by producing false certificate.
There are 4 appeals.
There are 4 appeals filed by the state.
182, why did
The private respondent filed the appeal.
by mistake আসেনি? 182 আচ্ছা আচ্ছা। Yes.
Now, my lord, page 660, my lord, whereby the writ petitioner was dismissed from his service as Group D staff of the said school, and there was an observation to the extent of refunding the entire salaries.
Where you are reading?
My lord, page 660, my lord, just.
Yes. WPS
Yes, yes.
6156.
Was preferred by the writ petitioner entirely challenging the memo so and so dated 5th August 2013 issued by the DIs of Purba Midnapur, whereby the writ petitioner was dismissed from his service as Group D staff of the said school, and there was an observation to the extent of refunding the entire salaries which he drew during his tenure. By the said writ petition, a corrigendum dated 30th August 2013 issued by the concerned DI of schools was also questioned, whereby the concerned DI of schools altered his stand, and instead of dismissing the writ petitioner from his service, the said school was directed to take legal proceeding against the writ petitioner in accordance with Rule 28 subclause 8 of Management Rules. On this writ petition, at the motion stage, no interim order was passed, save and except direction for exchange of pleadings by these parties.
So that order of dismissal was transformed into an order
Of
that
this
initiate proceeding.
proceeding by the school authority.
So both the orders were challenged through the same.
Yes.
Heading. Next.
Now, my lord, the writ petition had to file another writ petition, being WPA 5819 of 2015, whereby challenge was thrown to the subsequent order passed by the DI of school dated 16 January 2015, by which the connected DI of concerned DI of schools directed the administrator of the said school, means Lakshi Abhinavo, to said school means the school where he worked, my lord, to restrain the writ petitioner from putting his signature on the staff attendant register of the said school, and the school authority was directed to submit a report in this regard. This writ petition was heard at the motion stage on 3rd March 2015. On 3rd March 2015, when a coordinate bench of this court stayed the operation of the said order of the DI of school dated 16th January 2015, primarily for a period of fortnight, and subsequently the interim order was extended by order dated 9th March 2015 by the coordinate bench until further order. Therefore, on combined reading of these two orders of coordinate bench dated 3rd March 2015 and 9th March 2015, it appears that interim order was passed staying the operation of the decision of the concerned DI of schools dated 16th January 2015 is still continuing. Now, the third writ petition, being WPA 17716 of 2018, is preferred by the writ petitioner, inter alia challenging the decision of the concerned DI of school contained in memo dated 7th May 2018, whereby it was decided that the writ petitioner is neither entitled to receive salary for the period he discharged his duties in terms of the interim order passed by this court in WPA 5819 of 2015, nor release of the retiral dues in view of the superannuation of the petitioner on 30th September 2016. On this writ petition, another coordinate bench passed an order dated 13th November 2018, whereby direction was given for exchange of affidavits between the parties with the direction, if there be any admissible dues payable to the petitioner on other benefits which cannot be withheld under any circumstances under the law, and the same shall be released in favor of the petitioner within certain time. And fourth, writ petition being WPA 25407 of 2018 was preferred by the writ petitioner, assailing the memo dated 6th June 2018 of the Director of Pension Provident Fund and Group Insurance, Government of West Bengal. One after another, my lord, the impugned order has passed, and that was challenged by the writ petition respondent hearing. Then they said DPPG also refused to process the literal dues in favor of the writ petitioner by placing reliance on the decision of the DI of schools taken against the writ petitioner, whereby the entitlement of the writ petitioner to receive literal dues was denied. Now, my lord, for the aforesaid reason, the aforementioned 4 writ petitions are before this court and are considered in presence of the learned advocates representing the parties. Now, my lord, then, my lord, Mr. Chittapriya Ghosh, learned advocate representing the writ petitioner in all the 4 writ petitions has submitted. The writ petitioner was appointed as Group D staff of the said school on 1st March 1980. During his tenure, the writ petitioner's elder brother, Bhagyadhar Mandal, lodged a complaint against the writ petitioner, alleging the production of 4th school leaving certificate while obtaining employment as Group D staff of the said school, and pursuant thereto, an order of magistrate was passed under section 156(3) CRPC. HGPS case started and against the writ petitioner. After a full-fledged trial before the criminal court, a final judgment was delivered by the Judicial Magistrate First Class Third Court, Kontai, on 24th March 2008, and the relevant part of the said judgment is quoted below. You'll also already seen the
Next.
next, my lord.
Accused person Vidyadhar Mandal.
Yes.
Vidyadhar was the complainant. Huh?
Bhagyadhar was complainant.
Vidyadhar was, my lord, the
yes, next. The decision of the judicial magistrate.
yes. Question by the de facto complainant by filing a criminal divisional application.
4th March is the order which has been quoted.
Yes, my lord. Page 664, second paragraph.
By filing a criminal division.
725 of 2009 was disposed of by the order dated 3rd January 2012 by a coordinate bench taking criminal divisional matter, and the relevant part of this code was started, my lord, stated in the taking everything.
That was also dismissed.
Yes.
Next.
Now, my lord, on relating of 2 judgments was delivered. Next paragraph, my lord. 24th March 2008, in the order of the High Court while disposing of the conducted criminal liberation application, according to the writ petitioner, it goes to show the writ petitioner was not found guilty of committing any fraud as alleged against him by lodging complaint by his elder brother. It has also been submitted that in terms of the order of the coordinate bench passed on the writ petition WPN 5819 of 2015, dated 3rd March 2015, the writ petitioner worked as Group D staff of the said school till the date of his superannuation, dated
3rd March
2015.
That is the stay of the operation of the
Yes.
order.
Now
he was restrained from putting
signature and joining my
this means having terms of the order of the Satansa, if you work till the date. Yes.
Now, my lord, next paragraph, it is contended that in view of the acquittal of the writ petitioner by the criminal court and subsequent affirmation of the said order of the Honorable High Court, while disposing of the connected criminal divisional application, and absence of initiation of any disciplinary proceedings by the said school authority being competent authority, it was wrongly stated as proceeding initiated by the school authority. The disciplinary proceeding initiated by the school authority.
This was wrong, I got.
Yes. Now the writ petitioner is entitled to receive, single bench observation, my lord, receive his retiral dues, including area salaries, for discharging his duty till the date of his superannuation, which was wrongly been denied by the DI of schools as well as DPPG, the orders of whom have been put under challenge in 2 separate writ petitions as aforesaid. Your Lordship got it. In support of the such contention, attention of this court has been drawn to clause 19(5) of the West Bengal Recognized Non-Educational Inclusive Death Cum Retirement Scheme 1981. By placing reliance upon the DCRB scheme of 1981, it is submitted that on the date of retirement of the writ petitioner, no judicial or disciplinary proceeding was pending against the writ petitioner. That is also wrong.
Yes.
And therefore, in terms of the said clause 19(5), the petitioner is entitled to receive the retiral dues, including area salary, which was not paid to him by the respondent authorities, though he discharged his duty in terms of the interim order dated 3rd March 2015.
Yes.
In support of such contention, reliance has been yes.
Next, par contra.
Nominal par contrary, M.S. Chaitali Bhattacharya, learned advocate, appears on behalf of the state respondent in so has made the following submission for consideration by this court at the time of disposal of the writ petition. The concerned DI of school, by passing necessary orders, though directed the said school authority to initiate disciplinary proceeding against the writ petition in terms of the Rule 28 of the management rules, the following are direction of concerned DI of school. The said school authority failed to initiate proceeding. This is also wrong submission. Pardon, please, this was.
Yes.
To unearth the truth related.
As per appreciation.
Yes, as per appreciation of M.S. Bhattacharya, the order of trial court dated 24th March 2008 was passed without taking note of the relevant materials and evidence produced before the trial court, including forensic report, which is annexed to the writ affidavit in opposition affirmed by the DI of school. It is very important for the adjudication of the present matter. It is also contended on behalf of the state respondent that since the order of the trial court dated 24th March 2008 is not based on the relevant materials and the forensic report, therefore the writ court, being the court of equity, can exercise its authority in order to find out the veracity of the charges leveled against the writ petitioner by his elder brother, especially when the allegation is commission of fraud by the writ petitioner. It is also submitted that since it is case of fraud, without initiating disciplinary proceedings is wrong submission, wrong recording. Decision can be taken by the concerned respondent authorities not to release retiral dues in his favor. Though the disciplinary proceeding was initiated by the school authority.
Yes.
It is contended that the writ petitioner did not cooperate with the DI of schools while taking decision relating to his entitlement to continue his service by attending the school regularly, as well as his entitlement to receive retiral dues after his superannuation by producing necessary documents. Lastly, it is submitted that one Shekhar Manna, which was already been pointed out, that lodged a complaint against the writ petitioner, which led to initiation Khejur PS on 19th August 2013. The connected criminal proceeding is alive. Therefore, the writ petitioner is not entitled to receive pension and gratuity during the subsistence of the said criminal proceeding.
It was date of retirement.
Milord,
30th September 2016.
30th?
September 2016. But I have prepared a list of dates. May I hands up?
Yes.
M.S. Bhattacharya has strenuously argued on the point that the order of judicial magistrate while acquitting the writ petitioner was not based on relevant materials. Therefore, the writ court, being the court of equity, is empowered to enter into the complaints and the veracity of the allegation leveled against the writ petitioner while adjudicating the present writ petition in order to decide the entitlement of writ petitioner to receive retiral dues.
Yes.
Now, my lord, Mr. Arindam Chattopadhyay, so and so learned advocate responded, decision of the DI of school dated 5th August 2013 and the subsequent corrigendum have been questioned. Now, my Lord Chattopadhyay has.
He has adopted the submission.
Yes, yes, Abhishek Bhattacharya.
Now WPA 17716.
Now, my Lord.
The hard. That WPA WPA 17716 was by the villagers.
No, by me. 4 represent by me.
Very good. Now, Kajol Roy.
Advocate representing Miller 1 Shekhar Manna in WPS 6156 of 2014 submits that said Shekhar Manna is residing in the same village where the said school is situated, who lodged complaint against the writ petitioner on 19th August 2013, which gave rise to KJP so and so. On query of this court, it is submitted on behalf of the respondent number 11 that said Shekhar Manna is neither guardian nor member of the managing committee of the said school and is nowhere related to the said school in question. However, it has been submitted that after initiation of the criminal case, KJPS so and so, the writ petitioner challenged the same by filing criminal divisional application.
There was only one complaint case. KJPS.
One is by Milord, the villager Shekhar Manna, and one is elder brother of.
Elder brother case is what is the date of that? What is the
Milord,
number
that is Milord.
Number of that case is.
Yes, I am showing that.
That was disposed of on 24th
Milord,
March 2008.
that is Milord.
24th March 2008.
Yes.
And this Khejuri PS against this PS case.
That is 19th August 2013.
Petitioner challenged the same by filing a revision appeal.
For question.
As coordinate base passed an interim order and thereafter
Staying of the proceeding of KJPS
extended
and Milord.
After the general extension.
Interim order for general extension, then special.
Well, it disposed of and criminal case quashed.
Quashed. When it was set.
It was quashed on.
Where is your list of dates?
Here is my list of dates.
Don't have copy.
Yes, I have copy. I also given him copy.
This was also quashed.
No,
all right. Now kindly come to Mr. Das. You kindly come to now so that you can interim order was extended. And now next page submitted by Mr. Roy.
Yes.
By the private respondent. Private respondent is the person who lodged the complaint.
Yes. Now the fifth appeal filed by
Mad 182.
The appeal.
Shekhar Manna.
Not listed.
Which was I Miller initially pointed out that matter is not listed. That is Miller.
But though
Shekhar Manna's appeal has writ petition was also disposed of by.
He has not filed any writ petition. He was a private respondent.
শেখর মান্না একটাতে রেসপন্ডেন্ট নাম্বার 11
disposed of.
Yes.
What is your argument is now that it was passed on a wrong fact.
Yes.
That disciplinary proceeding was never initiated.
Yes. Disciplinary. Yes.
This is your only ground
No,
of
not only ground. Second thing is this, my lord, I shall demonstrate. My lord, the one, my lord, the several lead petitions.
finished.
Yes, yes.
Now such and such. Now court said that
Yes.
19.5 has to be considered.
Yes.
19.5 says
Final pension.
that disciplinary proceeding, and if there is any judicial proceeding pending, you will be entitled to provisional.
Yes.
Now, next, it has been provided under 19.5, final pension shall not be sanctioned.
Yes. Now, according to the court, 675 page. According, yes.
Second line.
Yes.
Page 67. Internal page 16 of the judgment.
Yes.
Top. Second.
On the qualifying service of the date of retirement.
Now, here in the present case,
So no departmental proceeding has been initiated by the disciplinary authority.
this is wrong.
Yes.
Yes.
But the fact remains that one of the two criminal proceedings initiated against the prisoner has culminated into an order of acquittal, which was affirmed by the Honorable High Court while disposing of the connected criminal revisional application. But another criminal revisional application at the instance of the writ petitioner is still pending. This court has been informed by the learned advocates representing the parties that the same is running in the list of the bench having determination. It is true that on the said criminal revisional application, which has arisen out of KJD PS 210 of 2013, dated 19 August 2013, a coordinate bench passed an order of stay of such proceedings upon the same being found to have been initiated on self-same fact wherein the writ petitioner had been acquitted, but the said revisional application is still pending for final adjudication before the High Court. Now, if at this stage clause 19.5 DCRB scheme 1981 is applied, the court is required to come to conclusion that the writ petitioner is entitled to receive provisional pension subject to the result of the criminal revisional application CRR so and so. This court also does not find any reason to deny the arrear salary of the writ petitioner for the period he rendered service as a Group D staff of the said school from 4th March 2015 till the date of superannuation, that is 30th September 2016, as per the interim order dated 3rd March 2015. Page 675, first paragraph. Now, next paragraph, my lord. Accordingly, this court directs the respondent authorities, including the District Inspector of Schools SC, Purba Medinipur, to sanction and release the provisional pension to the writ petitioner in terms of the clause 19.5 of the DCRB scheme 1981 within a period of 4 weeks from the date, and also release the arrear salary for the period of 4th March 2015 till the date of superannuation of the writ petitioner on 30th September 2016. The release of arrear salary shall be made by the respondent authorities within a reasonable period of time, but not later than 8 weeks from the date of communication of this order. Now, it is submitted on behalf of the writ petitioner that he was not paid salary from 14th February 2013. After the order passed by the DI of school addressed to the additional District Inspector of Schools SC Contest Subdivision, wherein the ADI of school was requested to withhold the salary of the writ petitioner. The writ petitioner submits that from 14th February 2013, though the petitioner had attended the school regularly and signed the attendance register, but he was not paid salary, and therefore the petitioner pays for a direction for release of salary from 14th February 2013 up to 3rd March 2015, near about 2 years. Since this court has already directed the respondent authorities to release salary of the petitioner with effect from 4th March 2015, since the orders of the concerned respondent authorities as contained in memorandum so and so, being number so and so, my lord, are set aside, this court grants liberty to the petitioner to make representation to the concerned District Inspector of School Purba Medinipur for releasing arrear salary for the period of 14th February to 3rd March 2015, which according to the petitioner has not been paid to him in spite of attending the school regularly within a period of 4 weeks from this date. The concerned DI of schools on receipt of such representation.
That representation was to be considered by.
Yes.
As regards the period from February to March.
Now,
Now tell us what is the wrong with this order.
yes. Now, my lord,
So the court gave two direction. Disperse the provisional pension gratuity. Now, when was the second application, criminal proceedings set aside?
2017.
2017. Huh? Then why did
My lord, may I just, I'm sorry, my lord. No. 3rd March 2022. I'm extremely sorry.
3rd March
2022 during
Then
pendency.
tell the court.
But this is pending during pendency of the appeal.
Order is of 13th of
Order impugned was passed earlier,
2021.
2021.
So have you brought this on record?
No, my lord, I filed.
Are you disputing this? You have no point to
my
dispute.
lord,
What you will dispute?
no. Now, my lord, I want to point out that, my lord, my lord, the coordinate bench, my lord, justice.
Now when it has been quashed, then provisional pension
No, thereafter, my lord, the state, my lord, file appeal.
against this.
Yes.
No.
Oh, what are
Criminal, there is no
Yes,
such appeal.
No. Yes.
All right, Mr. Dass. Now you
Now,
tell
my
us.
lord, in the challenging the order of the single bench, my lord, the state prefer an appeal. In present appeal, that is Mat 1016 first matter, my lord. Paper book which has filed, my lord. Page, my lord, 775. Page, kindly, my lord, draw your attention, my lord. Page 775, that is, my lord, order of stay. Passed by this 775, my lord, 775.
Appeal order.
Yes.
Still.
I also got it, my lord. My lord,
725.
775, my lord, 775.
Yes.
Order dated, my lord, 2nd January 2023, my lord. My lord,
At the time of admission of the appeal.
yes.
Yes. What you want to show?
Now, my lord, why, my lord, the coordinate bench granted stay? Why?
Stay.
Yes. My lord, may I read, my lord, without reading, my lord? The state is represented, my lord, second paragraph. The state is represented by the DI of school, Purba Medinipur, who is in appeal before this court, challenging the judgment and order dated single bench of so-and-so, passed in batch of 4 writ petitions. Each of the 4 writ petitions concerned respondent number 1 is writ petitioner. At the heart of this controversy is the claim of the DI of school. The respondent number 1 writ petitioner has obtained his appointment to a group D post to the school in issue by producing fraudulent documents connected to his eligibility. My lord, group D pass is required, my lord, class 8. He has not passed the class 8. Now, next paragraph. Learned counsel appearing for the appellants with so-and-so, my lord, that it is in public interest that a fraudulent appointee ought not to receive salary and superannuation benefits. It is submitted that, in spite of several requests by the said DI of school to the respondents, the school authority who appointed the respondent number 1, the writ petitioner, the school authority did not act on such request and kept the departmental inquiry pending against the writ petitioner, respondent number 1. The appellants submit that the Honorable Single Bench by the order impugned also failed to consider the effect of a forensic investigation initiated on the basis of a criminal complaint filed by a third party against the writ petitioner, which clearly discloses the commission of fraud by the writ petitioner in securing his appointment. This is very vital. It is alleged that the school authority has acted hand in glove with the writ petitioner to perpetuate such fraud. Reliance placed, my lord, to stress the point that it is duty of the appropriate court to rule against an appointment obtained by fraud. That is, my lord, first point, appointment initiated by fraud.
Yes.
In spite of notice, the school is not represented. Mr. Chittapriya Ghosh, Learned Counsel, appears for the respondent number 1 writ petitioner has submits that criminal complaint lodged by the third parties against the writ petitioner have not succeeded in courts of law. The writ petitioner has been ultimately acquitted of all criminal charges. The writ petitioner deserves to be paid against the actual service rendered by him to the school in issue. It is submitted that removal of dismissal of an employee as provided by management rules must follow the procedure for punishment as provided by the said rules. It is submitted that writ petitioner, the respondent, cannot be penalized with a punishment following his retirement from service. Second, Reliance placed, having considered the rival submissions and the materials placed, this court finds that the judgment and order of the Honorable Single Bench, as impugned in this appeal, has dealt with a wide array of facts covering each of 4 writ petitions. Each of the factual position, next page, my lord.
Yes.
Next page, my lord. Each of the factual position discussed by the Honorable Single Bench for and against either of the parties arguably requires scrutiny in this appeal. Now, while on the one hand, the stand of the appellant DI school to the effect that a fraudulent appointment cannot be allowed to go through unpunished deserves consideration by court. On the other hand,
Yes.
the manner in which such alleged fraud has been dealt with at different administrative and appropriate judicial levels is also deserving of consideration in this appeal. This court also cannot lose sight of the fact that in the event the order of Honorable Single Bench is allowed to be implemented during the pendency of this appeal, the same may amount to grant a complete relief to the writ petitioner, even at the interim stage in this appeal. Apropos the above discussion, the court is of the view that the order impugned of the Honorable Single Bench deserves to be stayed pending hearing of this appeal. Now, accordingly, let there be stay of operation of the order dated 30th December 2021 until further orders. So, still late, my lord, that was in force till the disposal of the appeal. Now, my lord, I pointed out 2 things, my lord. One is, my lord, the date of superannuation, which was stated by the writ petition respondent. That is also, my lord, objected. As such, my lord, the documents produced before the court in several writ petition, my lord, your lordship, my lord, may I pointed out the documents. My lord, the date of birth is varied one to another. In one hand,
So you show us that
yes, yes,
your argument as regards fraud.
yes.
Here,
My lord, I shall
fraud has been failed to be established.
the document,
Criminal division also, it has attained final.
the documents has not tested ever. Maybe the proceeding has been dropped or disposed of my lord, the proceeding has been.
Question the order passed by the High Court.
No, my lord, my submission is this, my lord. The court can see the document whether the transfer certificate or the certificate produced to the court, to the school.
Wait, please, what you want to show to us?
Yes.
You want to show us which document?
Yes. Milord, Milord, volume 2, Milord.
Yes.
Milord, page 243. Volume 2, Milord. Milord, containing page 204 to Milord 418.
43.
Yes.
Yes.
Milord, name of the school, Milord, can you see the serial number 17, Milord, duplicate copy, Milord, name of the school, Subdi Sitanath Vidyapit HS, transfer certificate.
This is the fraudulent document.
Milord, no, I want to point out that here the date of birth is
This is the fraudulent document.
that also to be treated as
Also
yes,
the
yes,
harm letter.
yes, yes.
Your allegation of Bhagwadar was
Milord, I have to show now, Milord, there are two documents that in two documents the date of birth is not similar. So, Milord, which is the genuine? That has to be pointed out or has to be proved by the writ petitioner respondent one. Otherwise, date of superannuation on 30th June, I think. 30th June, Milord, cannot be, Milord, the superannuation date.
this document was alleged to
No. This document has been relied by the respondent to show that
Mr. Das, you are not answering our.
Milord, I have to show first, then, Milord, I shall argue the.
No, we will get confused.
Yes, Milord. Confusion creates by the respondent, Milord. Page 211. Yes, your also square is it.
We will not go to that unless you show.
Yes, I am showing, Milord. Page
Which document was claimed to be Bhagwadar to be a forged.
Page 211.
Page 211.
Yes.
Page 211.
Yes. Milord, that is, Milord, transfer certificate certified that Vidyadhar Mandal. Yes, yes, yes. Milord, the date of birth. Can you see the middle portion? There was no such date of birth.
দাদা এটা তো হয়ে গেছে অরিজিনালটা দেখাও
Original, you have to show. You have to show
অরিজিনালটা
that.
দিকে গেছে
Oh, why? Milord, this document.
Yes.
Let the respondent writ petitioner produce this code to whether this document is actually not in the shown in the said level as such, Milord, the document which was not produced before the court below, but in coordinate bench it was shown by them that I have already submitted the document before the court below, whether the criminal proceeding was initiated in a casualty PS connection. And court justice, Honorable Justice Dibanga Datta then was, Milord, in the paper book it was that yes, he called for this document and produced the court whether this document is genuine or not. Now, Milord, he present an application to withdrawal of the said certificate from the school, from the court concerned. Court passed an order, it is in the proceeding, Milord. Court passed an order that the petitioner never produced any document, the original certificate, or there was no such document pertaining this page 211 in the, Milord, court below. And, Milord, subsequently.
Don't follow. What is your argument?
Yes,
211.
I want to argue there, Milord. The two documents is produced. One is, Milord, to school. One is, Milord, the Subdi Sitanath Vidyapit, where I have shown to your lordship that the date of birth is there. 1954.
We come to that. What you are showing at page 211.
Yes, well, kindly see there was no date of birth, or there was a portion which was
By date of birth in the admission register,
yes,
this cannot be read.
yes.
Uh,
Reason was shown.
There is just good copy space 64.
No, next page is Milord typed it in copy.
Date of birth
Date of
recorded in the admission
yes,
register of
12 September 1956. Now your lordship shown the earlier page, which was I have shown Milord there.
page 243.
Yes, date was 1954. কোথায় গেল?
This was produced by who?
This was produced by the writ petitioner in a writ proceeding.
Date of birth differs.
Yes. Not only date of birth, Milord. In one document, he passed class 5, and in transfer certificate, it was recorded he was reading in class 9 in the stream and had passed the annual examination of promotion of class blank. Means class 8, I think.
Okay.
And Milord, next.
So the class 8 partial history.
uh,
243.
243 was issued on
Issued on Milord 14 February 2013.
very good. So your first argument is the date of birth recorded
And
differs.
superannuation.
Yes?
Date of birth, following the date of birth, superannuation date will be Milord.
So that
Yes.
date of birth differs, and one is of class 9 pass, other is of class 1.
Yes. So in a group D staff, it is required Milord to pass out class 8.
So you are ready to give him pension from 2018 then?
No, Milord, I have to show Milord the no. Milord, I have to show the document why the DI stop the payment or stop the Milord salary.
This is your contention. This has to be established.
Yes, I established one by one, Milord. Now, Milord, in the
This has to be established through a disciplinary procedure.
yes, Milord. Now, Milord.
Your DI cannot say.
No. In the Milord, in the
Your DI cannot say, since this date of birth is differing or this is the wrong.
DI cannot say. Yes, cannot say.
Has to be by a disciplinary.
Yes.
No,
Now, in another document, another point is this, Milord. In page number 211, in reason for leaving, this is very vital. Why he leaving the school? The portion which was produced by the writ petitioner, there was cut mark.
Reason for leaving.
Reason for leaving.
Yes, what is it?
In one, yes, Milord. Only Milord. Option of guardian. 5 is tick mark. Other lodges or the Milord 1 to Milord 6 paragraph are cutted by pen through. In a Milord proceeding, it was dealt with that the produced by the document, the remarks or reason of leaving, the produced by the another certificate, which there was no such cut mark. Milord, Milord, the page 211.
File affidavit.
Yes. School has filed in this respect. Yes, state also filed. They also filed.
So you are saying that the reason for leaving.
The cut mark was not there in a document, and here is the cut mark.
What cut mark?
We'll kind of see the page, Milord, page 211. Milord, reason for leaving. The pen mark, Milord, cut mark was there through the pen. reason of,
of guardian.
yes,
Yeah.
all other,
Where cut it, so where it can see.
but in other document, in the reason of living, everything was there in as far as the certificate. Yes, my lord. My lord. My lord, I could not find out, my lord, for a moment, my lord. My lord, the two,
Proceed on your
yes,
next
no, yes, my lord, in 211, before that 210, the letter shown by the by the writ petitioner, may I kindly see the letter 210, my lord, just before 211.
Yes.
There was a handwritten note or letter. আমি আপনাকে মিলর কাইন্ডলি সি দি লেটার মিলর আমার শিক্ষাগত যোগ্যতার অতি পুরনো ও যেখানে সেখানে পোকাতে কাটা মূল শংসাপত্র যা আপনার স্কুলের পূর্বতন প্রধান শিক্ষক রবীন্দ্রনাথ বেরা মহাশয় দিয়েছিলেন তা আপনার নিকট প্রদান করিলাম। Why, Milord, I am showing these, Milord, in page 209, Milord, there was a letter by the Milord Lucky Abhinava Vidyalaya to the Milord, to Milord writ petitioner respondent. Kindly see Milord 209. Why the salary stopped and Milord subsequent, kindly see the document Milord 209.
Yes, please.
Yes. Information of for submitting your qualification certificate regarding verification of your date of birth entered into your service book. Now, in reference to the above, you are directed to submit the necessary qualification certificate in support of your date of birth and qualification. It is entered in your service book immediately after receiving this letter.
Then what is 2010, 210?
Now, my lord,
আপনার দেওয়া 22/2013 অনুযায়ী বেগম এত আমি আপনাকে আজ 26/2/2000 তারিখে এতটা সময় আমার শিক্ষাগত যোগ্যতার অতি পুরনো
my lord, result of examination, my lord, I have submitted in earlier occasion that there was, my lord, a forensic expert reported or the, my lord, examination was done on those documents and, my lord, report was there. The report is, my lord, kindly see the, my lord, 204, my lord.
in the pending criminal proceeding.
Yes.
Earlier proceeding.
That Bhagwata. 04, yes.
My lord, 204 and, my lord, type copy was there 204A, my lord. Kindly, my lord, may I read, my lord? The description of the articles contained in parcel 204A.
This was on the basis of criminal court order.
My lord, criminal code, my lord, never touched this document. As such, my lord, the
I am asking a
yes,
question,
yes.
you are
My lord,
answering.
sorry.
I am saying that this forensic test was directed by the criminal court.
During investigation, the forensic.
Yes.
During the investigation.
Yes, there was a forensic.
This investigation was conducted by the CID. Yes.
This is the forensic report.
Yes.
Yes, what I want to show.
My lord, on admission register of Lucky Abhinava Vidyalaya from 15 January 1969 to 13/11/1976, bearing the page number 1 to 84, the page number 1 to 7 containing the date of admission of different peoples from 15/1/1969 to 5/1/1970, available in the said register marked A by 1 to A by 7 in this laboratory. This disputed page number 8, 9, 10 and 11 inside the said register B by 1, B by 2, D by 1, D by 2 in this laboratory. The writings entered against serial number 30 Vidyadhar Mandal in different printed columns 1 to 24 in the said register marked C by 1, C by 2 respectively in this laboratory. The signature of English appeared against column number 18, 24 inside the enclosed writing against serial number 38 in the page. Result of examination. Exhibits are destroyed after 6 months if not requisitioned for return earlier through proper channel. The next one. The tint of ink available in the writing on page number 9 marked B by 2 was very carefully examined and compared with that of ink in the writings at page number 10 marked D by 1 with the aid of physical appliances, and results thereof are as follows. The tint of ink available in the writing on the page number 9 marked B by 2 is found to be dissimilar nature from that at D by 1. And next, my lord, the writings on page number 9 marked B by 2 when submitted to the examination under ultraviolet source of light yielded a difference in fluorescence from that the writings and page number 10 marked D by 1. The disputed writings appeared against the printed column numbers 12 to 24 in the enclosed portion inside page number 10 of bound register marked C by 2 were very carefully examined in this laboratory with the aid of physical appliances, and the result there are as follows. Marks of mechanical ensures are noticed in the region of existing writings inside column printed number so and so. Presence of overwriting with the application of a different tint of ink are noticed in the existing writing inside the columns number so and so. Previous writings underneath the existing writings in column number so and so. And Milord, this was signed and signature by the senior scientific officer, Milord, the forensic science laboratory. I have shown the documents, the certificate as well as the transfer certificate, and the marks of cut mark by through the pen.
Come to the next.
Yes, next, Milord, the no marks of disturbance or as noticed in the existing writing or entered against serial number 30 in column number 1 to 10, page number 9 of admission register C by 1.
Which column was the
The
of birth?
Yes, the date in the he write a letter to this
This is a forensic report pertaining to the attendance register.
attendance as a
It's not a forensic report relating to the certificate produced by him. These
Yes.
entries are pertaining to the attendance register.
Yes.
Very good. Now, what is your next point?
Now next one is this, Milord. I have to show the 514.
Yes.
Milord, the order was passed by the Milord Honorable Justice Rajiv Sharma then was, and Milord, in terms of the said order, Milord, the Learned Advocate on record, Milord, made a representation to the authority concerned, to the District Inspector of Schools, Milord, and Milord, writ petition was moved for Milord area salary, which was stopped by the concerned DI or ADI of the contract. Milord, now Milord, I am read out, Milord. Has you also got it? The writ petition bearing number 199905 of 2017, filed by the petitioner, was moved before the Honorable Court with a prayer to give arrear salary with effect from the month of February 2013 onwards, till the date of retirement of the petitioner, that is up to September 3, 2016. Now, my lord, date of superannuation is altered. It is his writ petition and his prayed that unpaid area salary has to be paid, and he retired, my lord.
30th September.
No, September 3, 2016. Kindly see the third line.
His date of return 30th September, but it is written September 3.
In a pleadings it was there, that is September 3, 2016. In the writ petition concept.
No, your contention is that
Date of superannuation is also altered following the date of birth.
I altered করবে. This is a typographical error.
Maybe.
It should be 30th September instead of this is September. So thus make legal argument.
Milord, this is Milord, in the writ petition it was in the writ petition it was his pleadings, his document. He is showing the court that my date of superannuation is this.
So your argument will be
Yes.
that argument will be that he himself is not sure about his date of
Right. Yes, got it. I'm grateful.
Yes.
Now, after careful hearing of Milord Honorable Justice Rajiv Sharma then was, has passed an order dated 17th August 2017, which inter alia states, Milord, the order of portion was there. Accordingly, without going into the measure of the case, Milord, so the respondent number 3 and the respondent number 4 to dispose of the representation dated December 20. Yes. Now, Milord, the observation in pursuance paragraph 3, Milord, in pursuance of the aforesaid order dated 17th August 2017, our hearing was arranged in the chamber of the so-and-so, learned advocate of the petitioner and respondent concerned present. The next date of hearing was arranged. Yes. Now, during the period of hearing, it was revealed. It is very vital.
Yes.
The petitioner was an approved peon, Group D staff of Lucky Abhinava Vidyalaya under DI of School, Purva Medinipur. The petitioner retired from his service on 30th September 2016. It appears from the annexure P29. The petitioner has paid for release of salary withheld from February 2013 to September 2016. And
was the relevant?
Yes. Now, Milord, the order in portion. It appears from the submission made by the concerned DI of school. From the above noted reasoned order, it is clear that the petitioner is guilty of committing suppression of material fact and
Order of 12th of
Yes, my lord,
April.
I am showing it. The petitioner, my lord, showing after that, my lord, after concluding this. The petitioner has no qualification for being appointed as peon, Group D staff in the school in question. The minimum qualification under the recruitment rules for being appointed as Group D staff in class 8 was. The petitioner read up to class 5, and on that ground, the petitioner has no eligibility to become Group D staff of a secondary school. So, the appointment of the petitioner is a void appointment as per rule, and it should be treated as a case of non-appointment.
And what happens to the certificate at page 243? That was the certificate which was class 5 pass, no?
Yes,
That was class 5.
class 5.
But the forged document is class 9.
Transfer certificate,
Which do the date of births are different.
not tell.
Not only the schools are also different.
Yes, yes. Next. So he did not have the minimum qualification.
Yes. Now, my lord, next
Can
next
say
page.
that because he did not consider the certificate at page 243. 243 is the certificate on the basis of which he obtained the employment. Is it so?
Now, my lord, what?
Class 8 pass.
243 produced by them, showing that I passed read up to class 5 from a different school.
That is 6th of July 19th, that page 211.
211 is certificate produced by me.
On the basis of which you
I obtained the job.
Yes, sir.
Now, my lord,
So this was the order, it is not valid.
no, the appointment, my lord, the point of argument is this, my lord. The appointment is not valid. There was nullity and the fraud visited upon the document.
How it is a nullity? Your DI approved his appointment.
My lord,
Basis of
now, my lord,
what is your argument?
my argument is this, my lord. The again and again apply, read petition filed by this before this honorable court, my lord, and order was granted. And in despite of that order, my lord, the authority concerned passed the order. In the order of DPPG, it was there, my lord, and what is the passed by the DI? Yes, now, my lord, now my argument is this, my lord. The order of DPPG as well as the DI concerned is reasonable. The single bench passed the order setting aside or the my lord quashing the impugned memo or the order passed by the authority are genuine.
That has to be.
Yes, 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 yes.
You don't have to say that also because that is the.
No, there are large document is here, there are so many large documents. I cannot in one day of hearing I cannot satisfy your loss. Now,
Don't take this ground, Mr.
no, I am not taking. I am just
Last appeared. You ensured us.
now, my lord. Yes, yes. Now, my lord.
The document. Don't now put it on our ears.
No.
That it is a lengthy.
Now I have to.
Cannot take
No. I have to show the document, my lord.
Please show. We
Yes.
are not stopping you. Not that sort of a council, Mr. Trust.
My lord, order dated, my lord, 5th August 2013, my lord. That is another volume, my lord. Volume, my lord, volume 1.
Page.
Page, my lord, 129.
Page.
Page, my lord, 129. 129, my lord. Yes. It was marked, my lord, annexer P14, I think.
Show us the relevant.
Yes, relevant document, my lord. My lord, last paragraph. Page 130, my lord. And the question of approval given by the DI also, my lord, mentioned here.
Showing page 130.
Yes, my lord. My lord, before there, my lord, I want to, my lord, page 129, my lord, bottom portion, bottom paragraph.
Yes.
My lord, Sri Shekhar Manna, one writ petitioner, my lord, has also got it, my lord, submitted that the previous criminal case is a separate case and has no relation to this instant case. He stated that my lord, Arup Jana, the then secretary of Laksi Abhinava Vidyalaya, in his letter dated so and so, asked the petitioner to submit relevant document relating to his date of birth and qualification. but the petitioner was unable to submit any document. On 25th January 2010, the then secretary of the school informed the DISC Purba Medinipur that the then headmaster of the school reported him that there is no any document in the school record regarding date of birth and qualification of Vidyadhar Mandal.
All right, let us come to the finding.
Now,
What was the
now
perusing all
finding is this: perusing all the papers and submission of the concerned parties, it appears that date of birth and qualification of recorded in the transfer certificate issued by the school authority of Subdi Sitanath Vidyapit are genuine. And
the first certificate date of birth is manufactured?
no, first date of birth which was written in this certificate, it class 5, class 5, yes.
243.
Yes, class 5, it was genuine.
Yes,
Next.
243 was genuine, 2211 was fraud.
Yes, now the transfer certificate issued by the school authority of Lakhi Abhinava Vidyalaya is found false and manufactured. Sri Mondal has been proved that he entered into the service producing false and fraud class 9 pass certificate. This is very vital, Miller. So he is dismissed from his service with immediate effect, and there is no question of releasing salary, as he claimed, for rather he is directed to refund all the government money, as he received as salary since his date of joining, that is 1st March 1980. And the school authority is asked to take necessary steps for refunding all government money which was paid to the petitioner as salary.
Now, why are you saying that there was no disciplinary? There was a disciplinary procedure.
Yes.
What is your primary ground?
Milord, supplementary paper book was there in a short volume, Milord. Milord, the document, Milord, page 3 to Milord. The resolution of the school adopted resolution of MC of the Milord, page 27. Milord, paragraph Milord 6.
What is this page 20?
Page 20, Milord. This is Milord, page 27, Milord. This is a letter of Secretary of the Managing Committee of the Lakhi Abhinava Vidyalaya to the Milord District Inspector of Schools concerned.
Of page 27.
Yes, 13. Milord, in compliance to the subject noted above with the memos and reference, the undersigned
Following memo
and court's order.
as per Shokas notice dated Atul.
Yes.
Where is the Shokas notice? This is a reply to a Shokas notice issued by the DI.
By the Secretary School Authority. Yes. No, it was
DI is writing
yes,
to the DI,
to the DI.
in response to a memo.
Memo as well as the court's order. Reference was there.
Read the line.
Yes, yes.
Compliance of the
The
following
compliance of the following memos.
as per Shokas
Shokas notice. Yes.
Where is that 25? 20.
আমার এটা দাও লিস্ট অফ ডেটটা কোথায় গেল
By 18th November. All right, what do you want to show us in compliance such and such? Yes.
In compliance with the subject noted above, the memos and reference, the undersigned clears leave to stating as follows. My lord, the undersigned as well as school authority was unknown and helpless due to the order passed in the memo number so and so, as and when the corrigendum of so and so, while the matter was sub judice by this writ petition under Honorable Calcutta High Court, then the school authority could not supersede the law and jurisdiction. The certified copy of the order so and so. Now, due to the closure of the school on and puja milot so and so was not complied. Reply of memo dated so and so was sent to the vice school so and so for your
The headmaster.
secretary managing committee.
He was the
No. Group D staff, peon.
Secretary was the headmaster. Secretary should be the headmaster, right?
Yes, as per the management. The undersigned and the headmaster was remain present in the hearing date arranged by your office after court's order. The undersigned has already started the process as per management rules 28 subclause 8. The single bench.
charge sheet issue. Show us anything.
Wait,
Cost notice, charge
No.
sheet, anything.
My lord, there was no scope for filing charge sheet. Rather, no. Why, my lord? Why, my lord? A person during, my lord, the one.
But now taking the cue from the
No.
system.
If the latches on the part of the authorities, my lord,
Show us one document
Yes.
that disciplinary proceeding was initiated.
yes, my lord. This is the, my lord, pertaining to this document. Now, my lord, previous document. Kindly see.
Show us one document. This clause 6 is not sufficient to prove that there was an initiated disciplinary procedure.
The resolution, my lord, kindly see the.
But your lawyer himself said that there was no disciplinary procedure.
There was no.
Chaitanya Bhattacharya appeared as
There was no submission was made. There was no such disciplinary proceeding initiated. My submission before your lordship that the as per letter
initiated due to the wrong of the
no initiated, but this is pending due.
was that it was initiated. Page
My lord, so cause below page 13.
page 13.
Yes. Legible copy nahi. কি করে কি?
13.
Page 13A, my lord, this type copy, my lord. Page 13 is the, my lord. 8th October 2013.
It's a Shokas. This is a Shokas. Yes, any other document you want?
Letter was, my lord, to my lord Vidyadhar Mandal. That
About your qualification.
yes. For
That is not a Shokas.
now, my lord, resolution of the school authority was there, and you see the resolution.
Page 14.
There are so many resolutions, my lord.
Are you not ready, Mr. Das?
My lord, page Yes, Milord, page 18.
Yes, we have read last paragraph.
পূর্ব মেদিনীপুর জেলা সদস্য মিলর শ্রী fourth শ্রেণীর কর্মী শ্রী বিদ্যাধর মন্ডলকে তার পদ থেকে বরখাস্ত করেন। উক্ত আদেশ চ্যালেঞ্জ করে মন্ডল কলকাতা হাইকোর্টে মামলা দায়ের করেন। ডিআই পূর্ব মেদিনীপুর তার বিদ্যালয় পরিচালনা সমিতি ম্যানেজমেন্ট রুলস 28 অনুসরণ করে আইনানুগ ব্যবস্থা নেওয়ার নির্দেশ দেন। পূর্ববর্তী সভার বিচারাধীন কোনো সিদ্ধান্ত গৃহীত হয়নি। উক্ত মামলার সম্পর্কিত ইন্টারনেট কপি পাওয়া গিয়েছে। প্রধান শিক্ষক মহাশয় ইতিমধ্যে হাতে পেয়েছেন। বিষয়টি সর্বসমক্ষে বিশদ আলোচিত হয়। উপস্থিত সদস্যগণ সর্বসম্মতিক্রমে ম্যানেজমেন্ট রুলস 28 অনুসরণ করে শ্রী মন্ডল সম্পর্কে বিধিবদ্ধ ব্যবস্থা নেওয়ার দায়িত্ব প্রধান শিক্ষক এবং সম্পাদক মহাশয়কে উপর অর্পিত হয়। Milord, my condition is this, Milord.
Page 18.
Page 14 was resolution, meeting resolution 64. That was requesting to the
Which clause you read? Page 14.
page 14, Milord.
Where you read?
Continuation, page 18, Milord.
18 last paragraph you read?
Yes.
Yes.
18 and
আইনানুগ ব্যবস্থা নেওয়ার নির্দেশ দেন। পূর্ববর্তী সভার সিদ্ধান্ত
court is free to Milord, pass an order directing the authorities concerned to pay, or Milord, pass the order disposing of the petition, Milord, in this way. Now, my condition is this.
that there was a disciplinary process.
Procedure. It is another point.
On what basis you are making this argument? We have asked you show us any show cause, any charge sheet, any reply, anything.
That was not done due to the filing of the
Anything
plain.
else, Mr. Das?
Milord, if your lordship, Milord, permit me to file, Milord, written notes of argument, short written notes of argument, may I come?
Yes, any other page you want to show?
Milord, opposition reply, Milord, filed by the Milord school concern.
Show us. Which page is the
Memo of appeal.
page number? Yes, Mr. Das.
Yes,
Which page you are showing?
Page 680, volume 4.
Page 680.
680.
Milord, page 286. Not a pass. No, sorry.
The repetition, Dada.
Yes, page 200 and
Yes, Milord, My lord, it is, my lord, page number, my lord, the documents, affidavit. My lord, page 247, affidavit in opposition filed by the, my lord, the writ petitioner respondent. In the said,
Maybe.
yes, in
Which, show us which paragraph you are showing us. Page number and paragraph.
yes, my lord. My lord, page number 346, my lord. Why, my lord, this said writ petitioner restrained from, my lord?
46.
Yes, 346, my lord. This was a letter issued by the administrator to the HM of the Lucky Abhinava Vidyalaya, dated, my lord, 30th January 2015. Why the, my lord, Vidyadhar was stopped for putting his signature in the admission register?
Page 340.
Page 346, Annex P30. Yes. Subject is, my lord, to take immediate step for restraining Vidyadhar Mandal Group D staff from putting his signature in the staff attendance register of the school.
This was said as it. What you want to show here?
Now, my contention is this, my lord. Your lordship, my lord, the documents which I have shown to your lordship, that one is the certificate and another is, my lord, transfer certificate, and third thing is the, my lord, the forensic report, and fourth thing is this proceeding initiated. Though I am not satisfied with this proceeding, that your lordship was submitted, the submission of charge sheet was not. My submission or reply is this.
I couldn't do it because High Court.
Because there are, I think, my lord, 14 to 17 proceeding or the application was filed before this court.
14 to
17. One after another, my lord. Writ petition, criminal revision, along with all this.
So what is your argument?
Argument is this, my lord. Even if this is the argument by the school authority, but school is not present today, my argument is this, my lord. The proceeding has been initiated under the rule of 28, and that is not concluded or not finalized due to the filing of several repeated writ petition before this honorable court by the writ petitioner respondent, number one. So, my lord, the equity, good conscience, and, my lord, the fair play is not in the matter, my lord, by the state writ petitioner, the writ petitioner respondent, and, my lord, submission for this reason, my lord.
What is your argument?
My lord, if your lordship kindly see, my learned senior friend has took 4 points. First, disciplinary proceedings was initiated against the petitioner by the school authority. My lord, till now, for the last 2 hours, my learned senior friend could not able to substantiate or show a single document that even a show cause notice was issued. I'm not saying that they have obtained the permission from the West Bengal Board of Secondary Education or not.
Then that was not the rule.
There was the rule at that time of time.
28
Yes, because 2014, I retired in 2016. Entire process started after 2013 against me. Entire process started 2013 after the second FIR.
After second FIR.
Yes.
When was the first writ petition filed?
First writ petition filed is 2013.
2014.
2013, well, 2014, 6156 of 2014. If you also can you look into my list of dates. I have given all the dates one by one. But can you see first 12/9/1956. The actual date of birth of the petitioner as per transfer.
First, so when was the first memo which was issued challenged?
Yes, my lord. That is
First writ petition was of 2009.
initially 2009 to 2000. The first writ petition is 2013.
In your list of dates, it is elder brother writ petition.
Elder brother filed a writ petition against me. The public interest litigation. What happened? May I give you also the one by one? In 1988, the elder brother lodged a complaint against me before the learned magistrate. 88, that I obtained the job by producing false certificate. Not FIR was lodged. TID investigation was conducted. Ultimately, I and others co-accused who are the managing committee members of the school were acquitted. Elder brother preferred a revisional application challenging the order of acquittal before this honorable court. This honorable court pleased to dismiss the revisional application and also to uphold the order of acquittal. Volume 4, 659.
Yes.
Number, he preferred an appeal against the order of acquittal. The appeal was dismissed. Now, thereafter, my elder brother filed a public interest litigation against me, alleging that I have obtained the job by producing false certificate. So, take steps against it. The public interest litigation was dismissed. On the ground, this cannot be.
They are not mentioned in the final order.
That is not mentioned because this was prior 2009, 2008, 9, 10.
Entered into service on which day?
1980. I entered service on 15th January 1980.
So complaint was lodged contemporaneously.
In 1980.
Brother slept over the matter.
In 1988. I joined 1980.
Now, where is the order of the public interest litigation?
Yes, my lord. May I show the question?
In 2013, amendment was brought.
Yes. Yes, my lord. The amendment was brought.
28?
Yes. Amendment was brought.
How did you rely upon Durgadas Basu?
Durgadas Basu
was on the old.
No, Durgadas Basu says that unless upon retirement, upon completion of
Was that first DI's first memo which was challenged?
Yes.
But dismissed.
Yes.
That was on 2013.
Yes, Malat, kindly come to page 129 in volume 1.
Yes.
But may I read for your lordship?
No, this has been placed.
These 129 not placed before your lordship. Now, the relevant paragraph is 130, the last paragraph. Pursuing all papers and submissions of the concerned parties, it appears that the date of birth and qualification are recorded in transfer certificate issued by the school authority or Subdi Sitanath Vidyapit. Well, here what happened, my lord, I produced the certificate of Lucky Abhinav Vidyalaya, saying that I was in the class 9, and also left the school. They produce a certificate of another school to substantiate that my certificate is forged. Are genuine, the transfer certificate issued.
In those two documents, your date of birth was different.
Yes, because in this is the both are the separate school.
So you can differ.
No, I never read in the Subdi school because it is in the charge sheet also. That is why the learned trial court acquitted me. In the charge sheet, the police himself, lordship, sees the document of the Lucky Vidyapit, where your lordship will find that they says the name of the petition is appearing. May I show it to your lordship? Kindly see those two documents once. Page 215
something. This
Yes,
what you want to show here.
the transfer certificate issued by the school authority, thereafter it says, and there is no question for releasing salary as he is claimed.
Because there is difference between the two certificates.
Yes,
That is this.
that is it. Kindly see the date. This is dated
2013.
2013, August 2013. Thereafter, my lord, this was challenged by me by your friend first writ petition in 2014. 16th Jan 6156 of 2014. Now, if you also kindly look into the two documents, which I like to show you, 2000 page 215 and 16. 215 and 16. That is in volume 2. This is the charge sheet of the 1988 case. The charge sheet was filed in 1993. Page 215, got it? Kindly see serial number 1. Article seized during investigation. 1. Admission register of Lucky Obhinav Vidyalaya from 15/1/69 to 30th November 76. যাহার 9/1/70 তারিখে সিরিয়াল বিদ্যাধর মন্ডলের নাম অষ্টম শ্রেণীতে ভর্তি লেখা আছে। আমরা কাইন্ডলি সি দ্য নেক্সট পেজ, page 216. This is another lordship seizure list. Progress report register 1970 to 73 5 to 8. যাহার অপাত্য নহে সিরিয়ালে বিদ্যাধর মন্ডলের নাম লেখা 1969 to 1975, যাহার 71 সালে 14 নম্বর সিরিয়ালে এবং 72 সালে 18 নম্বর সিরিয়ালে বিদ্যাধরের নাম যাহাতে দশম শ্রেণীতে উন্নীত হইল দেখানো আছে। This was seized by the police from the school itself. This is from the charge sheet, and charge sheet filed by the CID, not by the police.
You were not promoted to class 10.
I promoted to class reading in class 10 and left the school. That is the certificate. Not kindly see the certificate my learned friend shows to your lordship.
211.
Yes.
Promoted to class 10.
Yes, I promoted to class 10.
This is of the school Lokhi Obhinav.
Yes.
So what you are wanting to
But they are saying that I'm not reading in Lokhi Obhinav. I'm reading in a separate school.
That was in class 5.
I read in the school class. Yes.
Page 243 is a certificate issued to you.
In class 1 to 4, I read in Lokhi. That was the report I showed to your lordship.
Wait, then what is page 243?
That is a challenge. This document created against me, created against me to lordship not to give my salaries and others. This document was never proved before any court of law.
Mr. Ghosh, your client never went to this Shubdishita.
No, never.
Study up to class
Lucky Obhinav High School. I never studied in Lokhi. Shubdi. I'm sorry, madam. Shubdi.
Where have you stated that?
But this was came up through an opposition. In reply, I have stated. Let me show you your lordship my reply. দাঁড়াও, রিপ্লাইটা দেখো তো, আমি বলে দিচ্ছি। না না, উতে আছে। 8 Rule 28 Sub Rule 8. Both in aided and unaided institution, the committee shall have the power, subject to the prior approval of the board, to remove or dismiss permanent or temporary teachers and other employees. For this purpose, the committee shall first draw up formal proceeding and issue charge sheet to the teacher or the employee concerned and offer him reasonable facilities for defending himself. That is done by the school. School has never issued any show cause or charge sheet against me. This was the rules, but is it required to be ratified by the board ultimately? But
unless it is initiated, what?
No charge sheet has been issued, even not a single show cause notice has been issued against me till my date of retirement. And secondly, my learned senior appendix took out the point of forensic report. Number regarding forensic report, the said forensic report was never tendered before the learned trial court in a criminal proceedings. Not even before this court. A document which is not in even before lordship but tendered cannot be taken into consideration in the department proceedings also or before this honorable court. The forensic report was never been tendered before the learned trial court. A document not even been tendered, not even show the light of the day, cannot be used as a evidence against me for departmental proceedings or terminate me from my service. But firstly and secondly, if you also kindly look into the report, the forensic report prepared by the forensic report is at page. Yes, my lord, 204. If you also kindly see.
That is the forensic report pertaining to the attendance list.
Attendance register. Number kindly see who has issued. Senior Scientific Officer QD Section Forensic Selected Laboratory Government of West Bengal. But he has no authority to prepare the forensic report as per the Code of Criminal Procedure.
Why it was done?
This was done by the CID.
Pursuant to
Their investigation.
CID investigation was on the basis of the complaint lodged by your brother.
Yes.
Your brother lodged the complaint in 1988.
8. Charge sheet 1993.
So that forensic report was not referred to in the charge sheet?
Yes, it has been referred. Well, kindly see charge sheet. I have showed to your lordship. Kindly see page 215 onwards. Kindly come to page 221.
Then how did the court not take into account?
That was not tendered before the learned trial court.
Part of the charge sheet.
But that may be charge sheet, but a document which was relied by the investigating officer or the investigating agency is required to be tendered and required to be proved by a trial. That is why the trial is required. And a trial court specifically stated. Now, if you also kindly see page 221, the last serial 27, the witness, Sri S. Ghosh, Senior Scientific Officer, GDEB Section, FSL, Bulgaria, Calcutta 37.
So he was a witness.
He was a witness. He never appeared before the trial court for give evidence to prove the document.
So then it is a case of no evidence. That does not give you a clean sheet that you are a genuine person.
But that does not mean, maybe that does not mean a clean sheet, but does not prove a document which they want to use today. They want to use a document against me.
That they brought on record by way of his board did not consider that.
No, but kindly consider, even in case, suppose they have initiated disciplinary proceedings against me. Suppose they have initiated disciplinary proceedings against me. They produce the document before the departmental authority by investigating officer, inquiring officer. See, this is the forensic document. The inquiring officer cannot have the jurisdiction to look into that unless the same is proved by a particular officer. Yes, this is the document. This was used before the learned trial court, and learned trial court has taken into consideration. But I'll show your lordship judgment to that effect. I'm ready with that. Even in case of, even if I lordship kindly consider, if I say before the police that yes, I have forged the document and obtained the job, and police has wrote that statement in their charge sheet that Mr. So and so has admitted that this document has been forged by him to obtain the job. They cannot use it against me before the learned trial court or before the Department of Proceedings or before this honorable court unless that statement is proved.
This page 204 is a part of their opposition.
This is a part of their opposition. This is a part of their opposition, yes. And
the order of the magistrate setting aside this criminal proceeding.
Yes.
There is any reference to the forensic?
Lord, may I show to you, Lord?
Is that order?
Yes, ma'am. May I show it to you, Lord? Huh? Dao. Excellent. We're at page 180, volume 1.
180.
180. No. Sorry. No, I'm sorry, my lord. Not 180. It's 80. But kindly come to. So but kindly come to my lord, page 68. Page 68. Volume 1. Type copy is there.
Yes.
Page 68 it starts. 68A is the type copy. This is the operating part.
What is the other accused? What was the allegation?
That the headmaster of the school, the secretary of the school, or were
In collusion.
collusion, and they issued me certificate in 1980 itself, so that I can give, so that I can obtain a job in 1980. That was the FIR.
Was the FIR?
Yes, my lord. But FIR is at page 624, volume 3. Yes, ma'am. And 624 is the type copy. A relevant paragraph is page 626A. May read for your lordship. বিবরণ এই যে আসামি 1 নম্বর পঞ্চম শ্রেণী পর্যন্ত অধ্যয়ন করিয়া কয়েক মাস বেকারত্বর পর লক্ষ্মী অভিনব বিদ্যালয়ের ছাত্রবাসে পাঠকের উচ্চ বিদ্যালয়ের তদানীন্তন প্রধান শিক্ষক যুগ্ম সম্পাদক আসামি বাড়িতে কাজকর্ম করিত। যেহেতু 1 নম্বর আসামি 2 নম্বর আসামির অত্যন্ত প্রিয়পাত্র হইয়াছিল, গত ইংরেজি 31/1/80 তারিখে 2 নম্বর আসামি উক্ত বিদ্যালয়ের প্রধান শিক্ষকের পদ হইতে অবসর গ্রহণ করলে ওই বিদ্যালয়ের সম্পাদকের পদে নিযুক্ত ছিলেন। সেই সময় সরকার হইতে শিক্ষক অশিক্ষক কর্মচারীদের সমস্ত প্রকার বেতনাদির ভার গ্রহণ করিবার ঘোষণা করিলে আসামিগণ সরকারি অর্থ আত্মসাৎ করিবার কুমতলবে পরস্পর যোগাযোগ করিয়া 2 নম্বর আসামি 1 নম্বর আসামিকে ওই লক্ষ্মী অভিনব বিদ্যালয়ে 10ম শ্রেণীর ছাত্র হিসাবে একটি মিথ্যা ও জাল সার্টিফিকেট দিয়া 2 নম্বর আসামি 1 নম্বর আসামি
The order, page 68, what you are saying.
Yes, ma'am. This was the relevant, kindly come to ordering portions, which was relevant. This is acute.
The discussion as regards.
Yes, madam, I'm showing to you.
Judgment is ready
I'm showing the relevant paragraph. Kindly come to page 74. 74A is the type copy. Against the accused person under section 465, 468, 471, 120B IPC, the charge so framed was read over and explained to the accused persons in vernacular to which they pleaded not guilty and claimed to be the day saying each of them. Hence the trial as well. Signature of the de facto complainant on seizure list has been marked as Exhibit 1-1. Exhibit 2, the written complaint is marked as signature of the Gohaburi. Number, this kindly come the next page, 77A, 75A. Decision with reason. 75A, decision with reason. PW1 Bhagwatar Mondol, who is the de facto complainant of this case.
Where is the reference to the forensic? Must not have been because it was not tendered in evidence.
No, it was not tendered in evidence.
It was not an exhibited document. Sure about that?
Yes, yes.
My lord, I have submitted that it was not done. That's why, my lord, the proceeding of the trial court is where in law. my lord.
Forensic report is pertaining to the attendance register.
Attendant register.
It is not pertaining to this
I could not find. They have annexed. They can show it to your lordship.
Yes, anything else you want to show?
But that is all, my lord, regarding forensic report. I stated appointment visited by order of. My lord,
Now you also want a modification of the judgment.
yes, my lord.
Judgment was that provisional pension, ADR salary period, and the alleged period from such and such. Now your entitlement is for full pension.
Full pension.
But how can we give you that pension unless you bring on record documents and subsequent. Your findings, you have no demands. You did not
Nothing.
prefer appeal. It was, but today the fact scenario has changed.
Today, as on date, my lord, during the pendency of the appeal, my lord, I have been.
You did not take steps before the learned single judge.
No, my lord, since the appeal is pending, I've already filed a contempt application that is stayed by this honorable court. So, my lord, if
No, but you
otherwise,
should have asked for a modification of the learned single judge's order by virtue of the subsequent event.
since this honorable court has staged the order impugned, so the learned trial court,
It stayed.
it was stayed. Now তো আমাকে বলুন কোথায়?
Should have here.
Yes, my lord, that is on 2nd January 2023.
23.
775 page.
23.
Page 775.
With date of the order.
My lord, date of the order 2nd January 2023.
2nd of January.
2023.
Just. A was 2nd of January.
2023. Yes.
Page.
Page 775. Volume 4.
On that date also, Mr. Ghosh, you did not bring the notice to this court that your subsequent application has been dismissed.
No, my lord, it was not recorded there, but
Then it's not a case, you have to go back and review.
but if you lordship otherwise in my favor,
Show us. Yes.
then I have to go to the review or I have to file a second writ petition. Because I have already made a representation. After obtaining this order, I made a representation before them.
Did you annex the copy
Yes.
of the dismissal of this criminal?
Yes, I made a representation. It is on 15th March 2023.
But that is restricted to the issue of arrears salary.
No, it was regarding that during the pendency of entire thing, I've been acquitted in the second criminal case, so give me the full pension. This was the representation. But may I read just only one paragraph? That accordingly, the criminal proceeding in connection with the
should be for ওটা তো দেখতেই পারে কোন নিচে দেখো দেখাতে পারবে না কেন
on 15th March 2022, thereby
Suppose today if we dismiss the appeal, which order revives? Stay order goes.
the order of the Honorable Single Bench.
The application also you did not inform the court that this fact scenario that today if you do not entertain my plea, then even if I succeed in the appeal, I will not be getting full relief.
That is, my lord,
So you have to show us something that in appeal, even if we suppose we will ask for that argument from you. Suppose we hold in your
the subsequent event. Yes, ma'am.
We also cannot act. One thing is troubling us that we also cannot close our eyes to this fact. No? Now today, upon upholding the order of the single judge, the matter is left. Your DI will not do anything. He will say no contempt. Now the fact situation has changed. Otherwise, our judgment will be bad.
আমাদের application
He has acted on. He has acted on the order.
You have acted on the order. At least at that stage, if you could have brought the court's notice to this fact.
But this was somehow it was not recorded. I showed it to someone to record it.
हाँ बोलिए सर सर কথা বলুন
Think, no?
But there are other documents my junior has given him, my lord, which can clearly indicate, my lord, fraud. The documents, my lord, It has
We have
been
seen the
manufactured.
document.
This document has not been seen by His Lordship.
Which document?
These are two documents, my lord. Just let us tell him.
Next to the memo of it.
Milord, all these documents, Milord, I have not given any reply. The document which was produced before your lordship in the paper book, which was filed by the state, by the respondent number one, writ petitioner. Milord, these documents, these are the documents. Shall I see? The
আমাকে
document,
কপি
Milord,
দাও কি দিচ্ছ করতে
আরে তোমার ছবি আছে।
This should be come up with an additional evidence.
What you are
আচ্ছা,
saying?
সেগুলো আছে। Milord, আরে ওই document।
এটা তো আছে
The document
It is there.
শুনে
No, Milord, the cut marks was there, but there was no cut mark in that document.
The changes in the document.
I was argued, Milord, but it was not never shown to your lordship.
No, but this is your.
It was in the 77 certificate. Cartman was there.
No,
At page 211.
for such reason, Milord, Milord,
Yeah,
our
your mind
our
is
submission before your lordship, Milord, let the respondent state, writ petitioner be produced the document.
Which
The-
document?
the-
How can he produce?
The document of certificate which was he has relied upon that is my genuine certificate. That is the documents which was annexed in the writ petition in several writ petition, not tell you each other. In one in hand, Milord, in region behind the school, there was cut mark, and in other way they are putting that the document is not produced.
আমি একটু দেখলাম ওই document.
Justice Dipankar Datta then was, Milord, directed to the petitioner to produce the document.
না ওটা অরিজিনাল
ওটা আছে তো?
না ওটা ডুপ্লিকেট
আমি দেখিয়েছি ওটা। দেখো না এই যেটা এটা আছে ওটা কাট।
211 হচ্ছে হ্যাঁ এই কাটা রয়েছে এটা তো ও প্রডিউস না ও প্রডিউস তো বলছো ওকে প্রডিউস
show us any judgment to that effect.
Give me one day time. I collect ticket and tomorrow to be mentioned. I'll sell produce. Tomorrow to be mentioned. I'll sell.
This document, Mr. Ghosh, we have to bring on record. Now, there has to be an application.
Yes, Milord. Another thing is the Milord, the Lucky Abhinav, the custodian of the entire document, the Lucky Abhinav Vidyalaya. That should be represented before your lordship. Your lordship, that's why Milord directed to me.
Call them
No.
by the
Your lordship directed me to call them, Milord, to notice. We have issued the notice, and last occasion they are represented, I think. Milord,
They appear.
no, appear করেছিল এই কোড হয়।
Mr. Das, you are not the DI.
No,
You are the arguing counsel.
the arguing counsel on behalf of the
Identify yourself with the DI. Your DI is jumping so much because of this reason, because he has to clear a case where he did not have the opportunity to have control over the document. Because he must have gone into the post sometimes in 2020-22. He sees that according to him there is an illegality, government, state exchequer will be affected.
No, the observation of 2013
So
Milord.
the way you are arguing the
The
matter,
DI's order was 2013 and 12.
Pardon?
2013 Milord.
Yes, the way you are arguing is now you are telling the appeal court, you ask the school to produce the document.
No.
You ask the writ petitioner.
No. Today's Milord, there was resolution regarding short puja that if no in person Milord. No. My argument is this, Milord. Let the document be produced before your lordship for our satisfaction. Milord, as such, Milord, the document is vitiated.
On what ground we will do?
Brother.